All right. Well, if he shows up, we'll hear it. Okay. Tracy Fitzgerald, also Max Hirsch. Miss
Correct.
Hirsch, okay. Are we waiting on your counsel, Miss? Okay, let's go ahead and hold on that.
Yes, Your Honor, and just so that the court is aware, I do anticipate argument and possibly testimony. In that case, Officer Richardson is present. I'm just waiting on Sergeant McCarter.
Okay. Officer Richardson, okay. And Sergeant McCarter,
Potentially, yes, Judge.
okay. Needy Janice,
Oh, Andrew Fleischman here for Ms. Janice. Your Honor, I believe we're moving forward on a speedy trial motion today, a discharge and acquittal. I believe the state is asking for a continuance on some other portions due to witness unavailability. And I would just ask that we go through the factors of OCGA 17-825 and ensure the state is in compliance with all those factors for the continuance motion, Your Honor.
I'll do a preliminary check through on that, but we are going on the motion for speedy trial, all right?
Yes, Your Honor.
Okay. And then we have Jorge Perucho Flores.
Morning, Your Honor.
Mr. McClendon, good morning, sir.
I did not file any motions that would necessitate a hearing. I believe it's my discovery motions that somehow wound up on this hearing, so there are no motions that need to be heard.
All right, let's take your case up first then. What's still outstanding?
Nothing.
Nothing?
I have discovery, it's just my general motion to get the discovery was for some reason put on a motions count.
For some reason, I have no idea why either. Any chance, any opportunity for you and your prosecution to speak about the case?
I could talk with them.
All right, don't want you to make this a wasted trip, so. Is your client here? Is that your client back there?
He's here.
All right, is it with Miss Waldrop or Mr. Birch?
It'll be Mr. Birch, Judge.
All right, Mr. Hirsch has just arrived, so your client's back there, sir. And I'll address your cases shortly.
Okay.
We do have a court reporter on Zoom. And Mr. Birch, if you want to take a few moments to speak with Mr. McClendon, otherwise we'll just further notice the case for trial.
Thank you.
Mhm.
Yes, Your Honor. I'm sit out in the hallway.
And Ms. Waldrop, you have the, which case do you have? 1 and 2?
That is correct, Judge.
All right, so Mr. Hirsch is here. Mr. Fleischman, we will take up your case shortly. So in the meantime, I know you've already set up shop on the table. Would it be too much if we have Mr. Hirsch come up first?
I'll let Mr. Hirsch.
Thank you.
Your Honor.
Please.
Yeah.
All right, Mr. Hirsch, we have you have 2 clients on the calendar today, Daniel Oliver Beeson.
Yes, Your Honor. Thank you for holding for me. He's present. We're ready to proceed. What says the state?
Go ahead.
As I mentioned, Judge, the state filed a motion for continuance back on March 7th with regard to this case. We, in preparing for this motions calendar today, began sending out subpoenas to the agencies, arresting agencies on this case, which was Roswell PD. In response to our subpoena, we received a notice from Officer Lewis that he is on leave from his duties at Roswell for the dates of March 21st through March 22nd. He submitted that leave and it was approved by his supervisor back on February 27th of this year. So well before he was ever notified of the need to appear in this case, he had already scheduled his leave. It's my understanding that he is out of town, so he is unavailable. So the state would be requesting a motion, or excuse me, a continuance in the matter so that we can procure the testimony of Officer Lewis of Roswell. Officer Lewis is still around. He still works for the same agency that he did back in 2021 when he arrested the defendant on this case. So we do anticipate that we will be able to get him into court. He's not trying to avoid subpoena service. He simply has a conflict for today. Additionally, this is not made for the purposes of any delay. The court can further notice this case to a trial calendar, and we can hear motions right before trial if it's the intent of the court to move the case forward and keep it progressing on track to be resolved.
Okay,
So we would just ask that our continuance be granted.
all right. Mr. Hirsch, yes, sir.
Thank you, Your Honor. This case is about 3 years old. The officers leave, even if it was before the state sent notice, was not before the calendar was published, or that we got notice that last calendar saying that motions would be today. At that time, the state didn't know about this leave, nor do I know if it was filed, but the state didn't say anything. But in addition to that, Your Honor, this is the second or third time I've been on a motions calendar. I had one in front of Judge Edie. The state asked for a continuance then. And again, this officer is on leave. Leave is not a legal excuse. So I don't know that the state validly subpoenaed him. I can tell you they probably did not. I can also tell you that leave is not a legal excuse. I can tell you this case is 3 years old, and it was getting so old it left Judge Edie's courtroom to come here. The announcement that motions would be today was, I believe, if I recall correctly, sometime in January. My client is here. He's been here every time. He's anxiously awaiting a resolution in this case. He suffers from anxiety, and each time it gets continues, it gives him more anxiety. I can also tell you about a year ago in front of Judge Edie, the solicitor at the time said that they would review the video to see if it was a reckless case, which it obviously is. And that they would get back with me. They've never gotten back with me. That prosecutor is no longer on the case. So cases are here to be moved. Your Honor, this is a case that should have been moved a long time ago. There's no legal excuse for the officer not to be here, even if he was legally subpoenaed, which I can tell you he likely was not. So at this time, I would ask you to grant my motions to suppress.
Motion's denied. The next court date is going to be for a jury trial, at which time we will take up the case, the motions as well as motions in limine.
Your Honor, is that a notice, a date we'll get in the mail?
You will get a jury trial date the next time. You will not get a motions date. And I
Yeah.
don't have a date. Let me see.
Okay, so
So
we'll get it in
jury
the mail.
trial, yeah, I don't have one available right now.
All right.
A non-jury trial, bench trial is on June 21st. But I don't think y'all have asked for a bench trial, right?
I've not asked for one, no.
Okay, so further notice and we'll send you notice of a jury trial. Is your client able to drive? He should have had his license reinstated.
Mr. Beeson?
Yeah,
Yes, ma'am.
okay, so just want to be sure. Thank you.
And Judge, just for the record, I just want to clarify, you stated that the motion was denied.
Was
I'm thinking you're taking his
no, I'm sorry,
objection to
the
our.
motion to deny the continuance
Thank you.
is the objection to the,
Continuance. I understand now.
all right, let me get, I haven't had a cup of coffee this morning, so, okay. Your continuance is granted, the objection is denied.
Thank you.
Okay, go ahead. Okay, moving on, Mr. Hirsch, you have Tracy Fitzgerald, and we are ready to proceed on that. We have Officer Richardson here, and possibly Sergeant Carter is on call. Ms. Fitzgerald, you can come and have a seat with your attorney, and Mr. McClendon.
Your Honor, we anticipate working this out, but there's a couple issues that are gonna keep us from doing it today. May we put this on a plea calendar rather than a trial calendar with our good faith belief that we can resolve it?
Plea calendar will be May 10th at 1:30 PM.
Will I get any other notice?
Nope, this will be the one,
May 10th at 1:30.
May 10th at 1:30 PM. And you will get a written notice as well.
Okay.
But put this on your iPhone or whatever y'all use. Okay, thank you.
And Judge, if I may just make one suggestion. I
For
believe,
whom? For this case?
well, for the calendar.
Oh, okay.
I believe they are ready on argument for position number 3. My motion is gonna, I think, take longer than that. So if you wanted to go ahead and do that argument and get that case resolved.
All right,
And I'll.
we will do that.
Well, and Your Honor, may I make an announcement on Tracy Fitzgerald?
Yes.
I'm sorry that Officer Richardson has to be here, and we can go ahead with that motion if necessary, but I've also filed a plea in bar because the statute of limitations ran. It
Mhm.
seems to me like that's an easy,
No, I don't think so. I've already read it, but we'll take that all up after I've addressed the speedy trial demand
okay,
for the other case. Do you want an opportunity?
not a speedy trial demand.
No, I've got a speedy trial in
Oh,
another
oh, oh.
case.
I got you. Okay. All right, so we are on deck? Or are we up next?
You are, I've got Mr. Fleischman's case, then you're next.
Okay. Oh, that may be true.
Okay. Okay, yeah, yeah.
I'm told I just had that.
Just let me know.
Oh, my goodness. Really? And I said, but see, he goes, not so much. He said, "Be fast, you get
And I don't have that time. Okay.
You know, but she came and take her for a while. I think,
Might be a little longer because we,
all right.
Okay.
So, Mr. Fleischman, if you'd like to come up to the podium and present are you presenting any witnesses or testimony for your motion?
I believe I may. Your Honor, I might be calling Mr. Sessions to testify to certain aspects of the statute.
Okay, if you'd like to come up to the podium first, and present your motion, your opening statement. Meanwhile, Mr. Hirsch and Ms. Fitzgerald, you're gonna have to, just temporarily leave shop and then we'll come back.
Your Honor, can we have Ms. Janice come forward?
Yes.
Just for clarification purposes, Your Honor, the defense in State versus Janice filed a constitutional speedy yesterday afternoon at 12:53 PM,
Mhm.
which is different than the statutory speedy that was filed back in 2021. And so the state would object to going forward on the constitutional speedy today, considering that it was filed 4 hours and 7 business minutes before we were set to appear in court. And
Okay.
so which are we going to argue just for?
I don't know. I guess Mr. Fleischman will let me know what I'm supposed to hear and then I'll let you make your objections.
Yes,
Okay?
Your Honor.
Thank you.
All right, Your Honor, I'm inclined to argue both, and a statutory speedy trial demand functions as a constitutional speedy trial demand. So I think that the state's argument here might be misplaced. They received notice.
I don't know about that, sir, but go ahead, give it your best shot. Okay, right now we are addressing State versus Needy Janice 21 CR 004-110Y. Ms. Janice is present?
She is, Your Honor.
Right there, yeah. Good morning.
Good morning.
Ms. Janice, I just want to advise you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney and your counsel is Mr. Andrew Fleischman. Ms. Janice was cited for reckless driving, failure to maintain lane or improper lane change, and DUI driving under the influence of drugs, less safe on April 9th, 2020. All right, Mr. Fleischman, if you believe both motions should be addressed in tandem, why don't you first address why I should be hearing a motion for a constitutional motion for speedy trial filed some 4 hours ago?
Because it wasn't filed 4 hours ago, Your Honor. It was filed November 17th, 2021. A
Mhm.
demand for a statutory speedy trial puts the state on notice that we are requesting a speedy trial for constitutional purposes. I'm sorry, I don't have that case ready to pull up. I was not ready for that state's objection, but after I sit down, I will get it to Your Honor.
Okay,
They function the same.
so what was this recent filing all about? Is it a supplement to what you've already previously filed?
It is simply a motion for discharge and acquittal on the basis of the failure to grant constitutional speedy trial. So
I
there's nothing
see.
recent
All
about
right,
it.
let's go ahead and address the original motion for speedy trial as filed back in 2021.
Thank
Your
you, Your
opening
Honor.
statement. Yes, sir.
And I spoke with Mr. Birch outside. I hope he'll correct me if I'm wrong, but my understanding is that and I'm so sorry about this sound, might be my laptop's fault. Let me move that away.
Okay,
Um, Your Honor, I believe we're just going to focus on two issues today. Not whether the jury was impaneled or whether we served this on Your Honor, but simply whether this was a separate motion as required by law and whether we timely filed it. Okay. So as far as whether it is a separate motion, in a case called Rogers, and I'll pull up the site for you in a second, the Court of Appeals said that even unstapled motions filed on the same day are separate, so long as they're a separate certificate of service. And with the state's permission, I'd like to approach to show the certificate of service on this case. And do I have the state's permission? That's perfect. So as you can see, this demand for a speedy trial.
If you'd like to present it to the deputy, please. Thank you. Thank you.
I'm not intending to present this as an exhibit because of course it's already in the record, Your Honor, and I would ask the court to take judicial notice of that record. But as you can see, the statutory speedy trial motion has a separate and distinct certificate of service.
Mhm.
And according to the Court of Appeals, that's sufficient to make it separate and distinct. In that case, Rogers. Do you have that case handy, Your Honor?
Not handy right now, but please proceed. You're on your opening statement right now.
Thank you, Your Honor. That case, a site is 340 Georgia App 24.
Mhm.
It's a 2016 case, state made identical argument. Now, the second argument the state makes is more interesting. They argue that this was untimely filed. In other words, it was filed after the first term of court with accusation. And there's two responses to that. The first is that we were not given notice of the accusation. And so Mr. Sessions filed a motion saying, hey, you didn't give us notice. You deprived us of our right to demand a speedy trial. That's a problem. No court has addressed that yet, Your Honor. But obviously, part of due process is notice and the opportunity to be heard. And the failure to provide notice, as I'll call Mr. Sessions to testify to, is the basis for permitting a late filing. But second, and more important, this was during COVID-19. There was an order from Judge Edline. You're probably familiar with it, but I can present you with a copy.
I'm familiar with it. Yes, sir.
That
Please
told
proceed.
all statutory deadlines, statutory speedy trials, and that includes, under the statute cited, filing deadlines.
Your motion for a speedy trial is timely. Move on to the next subject.
Okay, Your Honor. Well, in that case, it was timely filed. And in fact, we did serve it as a separate document. Those were the state's only two concerns. For that reason, the motion should be granted. I'll hear from
No,
this.
now the question is, has it been violated?
Oh, sorry, Your Honor. It has been violated, Your Honor. More than under 15-6-3, more than two terms of court have passed since then. I would ask this court to take judicial notice that jurors were impaneled during that time. I don't believe the state has a good faith basis to argue otherwise. I'll call Mr. Sessions up to establish that.
All right.
Having been timely filed, more than two terms of court have elapsed. For that reason, the motion should be granted.
Okay, thank you. Mr. Birch, would you like to make your opening from your desk?
Yes, Your Honor. The state's position is that this statutory speedy trial demand that was filed on November 17th of 2021 is untimely due to the statute itself. The plain language of the statute itself clearly states that the demand for speedy trial must be filed within two terms of court of the accusation. Now, the defense has addressed the issue of notice of that accusation, and they have told you that that has not been brought up on.
If I find that notice is not an issue, why is it untimely, considering that there was a standing order that suspended all these timely factors?
Simply under the plain language of the statute, Your Honor.
Motion's timely. The motion that was filed, the demand for speedy trial as filed by the defense was
Okay.
timely.
So to the second issue of what
Yes,
the defense is called stapling, yet again, in the plain language of the statute, the motion for speedy trial is required to be filed as a separate and distinct motion. The clear title, I do have a printout of the docket itself. Nowhere on the docket does it show a motion for statutory speedy trial. And I can present this to Your Honor if you'd like to take a look.
I'm looking at it myself.
Okay, right. So if you look at the docket on November 17, 2021, the defense filed what is titled as motion for discovery consolidated. Now, if you open that document, you will find on the 25th and final page of that filing, a demand for speedy trial, which I have brought with me here today. This specific motion is not file stamped as a separate pleading. It's file stamped as a part of numerous other pleadings at the same exact time. Now, I do have a case site here. It is URIB, URIBE versus State, and that is 346 Georgia App 264. And the language of this specifically says the pleading requirements set forth in OCGA 17-7-170 are clear and unambiguous. We therefore give them their plain and ordinary meaning. URIB did not comply strictly with the pleading requirements in that statute. His pleading was not entitled Demand for Speedy Trial and was filed as part of another pleading, in this case, waiver of arraignment, not guilty plea, and demand for jury trial. Therefore, URIB did not properly file a statutory speedy trial demand pursuant to OCGA 17-7-170, and he's not entitled to discharge and acquittal pursuant to that statute. And so, accordingly, Your Honor, the state's position is that this statutory speedy trial demand was not filed in pursuant to the statute that they claim that it was. It was insufficient on the basis that it was attached to numerous other motions. It's not titled accordingly on the docket, and this should be denied.
All right. Mr. Fleischman, did you have a response or do you want to call your witness?
Both, Your Honor.
Okay.
Just very briefly. As you probably noticed, it is titled at the top, statutory speedy trial demand. So there's really no ambiguity about what it was. And whether or not the clerk treats it that way, and I'm so sorry for the sound that I am not producing.
Okay, that's fine. It's not bothering me, but okay, go ahead.
And in Rogers, the same lawyer, Benjamin Sessions, filed a motion in exactly the same way. And the Court of Appeals said, yes, this way of doing it is proper. It's hard to imagine a more on-point case than nearly identical filings filed in the then identical way as determined by the Court of Appeals. And for that reason, I think Rogers is likely the binding authority in this case.
I'm curious to know which document was it that you filed that's titled Demand for Speedy Trial that shows clearly on the
I'm going to bring this up to the court with your permission. Here we go.
no, this is your demand for speedy trial. This was buried in the motion for discovery.
Your Honor, it's not buried. It was separately filed with a separate certificate of service. And in Rogers, that is sufficient. So
Which pleading does it, I'm looking at three pleadings that were filed on November 17th,
Mhm.
2021. One says entry of appearance. One says motion for discovery consolidated. And the third one is demurs.
Your Honor, it was not part of, the clerk might have treated that as part of the discovery packet, but of course, under Rogers, this was filed as a separate and distinct document. More than that, if you check the certificate of
It's not
service,
filed as a separate and distinct document. I'm looking for it.
the clerk did not treat it as a separate and distinct document. That does not mean that it was not filed as a separate and distinct document. The clerk's mistakes are not our fault, Your Honor. And more to the point, this document was filed with the court. It was sent directly to the judge to notify the judge that this had been filed. You can see that in the certificate of service. That is all that Rogers
Let me
required.
see what was filed. Motion for discovery consolidated. And Mr. Birch is correct. When I was going through this document, I was looking for that demand for speedy trial. So I go through page 1, 2. Motion limine to exclude. On page 25.
Mhm.
Literally the last page.
So the Court of
You're
Appeals,
stretching it, Mr. Fleischman.
well, then the Court of Appeals stretched it when they affirmed the identical thing. That's the binding precedent.
You're telling me that the Court of Appeals looked at a document that was entitled Demand for Speedy Trial and said that that demand for speedy trial that's buried in the middle of a voluminous packet, that is adequate notice to someone who's reviewing the docket to say that the defendant has placed the state on notice that it has a demand for speedy trial.
I could read this out loud or Your Honor. could
No,
check.
I'm asking you, under this hypothetical,
Hypothetically, if there was no title at the top that said demand for speedy trial, it would not comply with the statute. But of course, there was a title at the top that said demand for statutory speedy trial. Now, the clerk may have misfiled it, but that is not the burden of the defendant to ensure that the clerk properly files things.
Okay.
We complied with the law under Rogers, and just briefly, moreover, Rogers' speedy trial demand was a reference 170. It was not stapled or otherwise bound to any other document filed that day, and it specifically identified the accusation number for Rogers' case. Consequently, Rogers' speedy trial demand complied with the pleading requirements.
Do y'all have a copy of those two cases, UREF and Rogers? Otherwise, I'm just going to be Googling that to look
Please,
for it.
please Google it. I'm sorry, Your Honor, I don't have a copy with me. The case number again is 340.
340 Georgia 24.
Exactly.
All right. In Rogers, the record shows that Rogers filed multiple documents in the same day, including his statutory speedy trial demand. Each document had a separate certificate of service, and each document was clearly and distinctly titled, including the speedy trial demand. Rogers' speedy trial demand was not stapled or otherwise bound to any other document filed that day, and it specifically identified the accusation number for Rogers' case. Consequently, Rogers' speedy trial demand complied with the pleading requirements set forth in OCGA 17-7-170. In the preamble with regards to the recitation of the facts as found by the appellate court, the demand for speedy trial as filed was titled Demand for Speedy Trial, served by hand delivery on the trial judge, the Solicitor General's office, and the state court clerk. It was not stapled or otherwise bound to any other document filed that day, and it specifically identified the accusation number for Rogers' case. Were these motions served on the trial judge at the time of filing?
Yes, sir. They were. And the certificate of service shows that. I hereby certify that I have served a true and accurate copy of the foregoing demand for speedy trial by depositing same in the United States mail with adequate postage affixed to ensure delivery to the Honorable Fred.
Excuse me, counsel, could you please slow down?
I'm sorry, ma'am. The certificate of service shows personal service to the Honorable Fred C. Eady, the office of the Fulton County Solicitor General's office, and the office of the Fulton County State Court Clerk. All were served.
So it was mailed.
It was mailed, Your Honor.
Okay. And was it bound with the motion for discovery as one packet?
No, Your Honor. I'll call Mr. Sessions to testify to this, but just like in Rogers, it was.
Did it have a
unstapled.
cover letter?
A cover letter, Your Honor.
Yes, identifying the motions that were included.
No, Your Honor.
Okay. Okay. Anything else, Mr. Fleischman?
No, Your Honor. If you're inclined to rule against, I would ask to call Mr. Sessions up for the appellate record.
Go ahead.
All right, Mr. Sessions, please.
Which side of you really like me to approach from?
You can sit at the table right there, or at your table, or at the podium. Oh, I'm sorry, to testify?
Yes, Your Honor.
Oh, okay, it's this table right here.
I'm gonna move, Your Honor.
You can move here.
Thank you, Your Honor.
It's a weirdly constructed courtroom.
As is. I'm gonna hang out here on the bar.
All right, just speak loudly because you need to be heard. Actually, you need to be closer to that table. So you need to be close to that mic, right there,
Thank you.
because our court reporter needs to hear it. Have a seat, Mr. Sessions. You're an officer of the court, so you don't need to be sworn in. Thank you.
Thank you.
Good morning, Mr. Sessions.
Morning.
And make sure you can be heard on that mic.
Ms. Winfrey, can you hear me?
Yeah. Ms.
Yes.
Winfrey, can you hear the
Yes.
witness?
Yes, I
Okay, go
can.
ahead.
Yes, ma'am.
Could you please identify yourself for the court?
I am Ben Sessions. I'm bar number 141280.
And are you counsel of record on this case?
I've represented Miss Jenna since the beginning of this case, yes.
What is your experience with statutory speedy trial demands?
I have, I think if you look through the docket of Fulton County, I have extensive experience with statutory speedy trial demands. Obviously, when they have to be filed, how they have to be filed. I was the lawyer for Han Rogers in the case that you were referencing.
Based on your knowledge and experience as a trial attorney who's experienced with these, what are the requirements statutorily to file a statutory speedy trial demand?
That demand must not be attached to, stapled to another document. I certainly understand, sorry, I don't mean to like just run on here. I certainly understand the court's reservation as it relates to that document being the last document in the packet that was there. This packet is the exact same packet that I filed in Han Rogers' case. I use that packet every time that I file a statutory speedy trial demand. And it is like, it is within my office. One of the most rigorous requirements is do not staple any motions packet. And I don't staple even a packet that doesn't include a statutory speedy trial demand. We send out packets that are just every motions packet that we file and submit to Fulton County State Court is not stapled. And I do it specifically for the statutory speedy trial purpose.
Is it your testimony today that the packet sent out in this case is identical to the packet sent out in Hannah Rogers' case as found by 240 Georgia App 24?
It is the same exact packet. And the reaction was in the trial court for Han Rogers was exactly the same. There was if you read the record in Han Rogers, you would realize that the trial judge, who I really respect and really like a lot, was very upset with me because he thought that I was hiding the ball by virtue of filing the packet like that. He thought that the pleading was at the end, and he said, you buried it in this voluminous packet of motions. And I thought it was my position then, it's my position now, and the Court of Appeals agreed with it, was that whenever a lawyer files a motions packet, the state has an obligation to actually read the motions or at least flip through them to see if there's a statutory speedy trial demand. And they didn't do it then, they didn't do it here.
Now, let me ask you, was there anything going on in November of 2021 that would have made you more likely to mail something than come down and serve it in person?
Yes, we were in the middle of COVID. I did make it a practice to routinely file statutory speedy trial demands during that period of time. I recognize that it was probably a time that they would be vulnerable to missing them. I recognize that. I thought it was also important to assert my client's right to a speedy trial because it wasn't clear at all that we were going to get back to a point in time where when we were going to get back to having jury trials. So I would have clients, for example, Miss Janice, who they wanted to get their case to a resolution. So I did this. But you had to, at that point in time, in order to like have access to the courts, you were mailing things at that point in time.
Okay, so at this point, you were not hand delivering documents.
I was not hand delivering. I hardly ever went to court during that period of time.
Is there any statutory requirement to hand deliver documents?
There is not. That is a valid certificate of service under our law.
One second. This is the demand for speedy trial we spoke to before. I'm going to show it to the witness. Approaching Mr. Sessions with a document. So could you please read this document for me? The title of it.
Yes, it is titled Demand for Speedy Trial. It includes the style of the case. It complies fully with the requirements of, I try to make these as absolutely clear as possible. I also purposefully format the document so that there is always a one-page demand for speedy trial. It is never in the middle of another pleading. It is always separate from my other pleadings. I'll speak to in just a moment, the clerk's handling of the pleadings. But in terms of the way that I prepare the packets, it always has its own certificate of service on it. That's the way that I format the document.
So is there a separate certificate of service on this page?
There is in fact a separate certificate of service. It is its own standalone document. That's the way that I format the document.
And at the risk of being repetitive, was this bound or stapled to any other document in this case?
This was not bound or stapled to any other document. This is a standalone pleading. Whenever it is submitted to the clerk's office, there is nothing that there's not a hole that's punched into it so that it is made a part of any other document. I also do not, whenever I'm filing the documents, it is not in between another motion. Like it isn't in between a motion in limine to exclude a blood or breath test on statutory grounds. It is a separate document, completely distinct from the other documents. In terms of the actual filing of it, whenever you go into the Fulton County State Court Clerk's office, you don't get to insist upon, and no one asks you, does this motion packet include a statutory speedy trial demand? There's never a question as to that. You just submit the documents and they file the documents. Sometimes the clerk that's there will, if you're there in person, will go through and actually like stamp the documents in front of you. But obviously it was during COVID, during a time where I was submitting the documents via mail. I don't know what the clerk does and I can't control what the clerk does. I just say, here are my documents, do with them as you may.
In your experience with the statutory filing requirements, is there any requirement that they be stamped separately?
There is no requirement whatsoever that they be stamped separately. I always send a second copy that's there to be sent back to my office. That is the copy that we have that was provided by the clerk's office.
Now, let me ask you, in your experience as a trial attorney, have there been jurors impaneled in Fulton County since 2021?
There unquestionably have been jurors that would have been available to try this case and that have in fact been impaneled to try other cases. I know obviously in this court, there have been at least one trial that I know of in the ORCA court.
Have you tried any cases since November 2021?
Been called to trial. I have not had to try a case in Fulton County State Court since I take this back. We tried Mr. Coates's case that was in front of Judge Porter. That would have been a panel that would have been available to do that. I also appeared on, if you look at the docket history for this case, this is a case where a statutory speedy trial demand has been pending for multiple years, where I actually appeared on a jury trial calendar in this case, where the case was not called to a trial.
Okay. When you receive a packet from the state, do you read the things the state says?
I don't know how you could receive a packet and not at least flip through it to see if there's anything that's interesting in there.
Do you feel like that's your obligation as an attorney to your client?
It is my obligation.
Okay. No further questions at this time.
All right. Mr. Birch, any questions of Mr. Sessions?
Yes, Your Honor. Can you hear me, Ms. Winfrey?
Yes.
Okay, wonderful. Mr. Sessions, do you have an independent recollection of the events that took place on November 17, 2021?
Yes.
What did you eat for breakfast that day?
I'm not sure.
What did you eat for lunch that day?
No,
What color suit did you wear to work that day?
I don't know.
Are you specifically the person who put this motions packet in the mail to the clerk's office on that day?
I am.
You are?
Yeah.
Okay. And are you aware that you could have put this in a separate envelope from the other 24 pages of motions that were filed?
Could have. Yes, sir.
And are you aware that if you had done that, it would have been treated as a specifically separate and distinct motion apart from the other 24 pages in this pleading document?
I don't know that. There's no way for you to know what the clerk's office will do and how it is that a clerk's office will handle that.
Right. But did you file the entry of appearance on the same day in a separate mailing?
I don't recall that I did that. My entry of appearance is typically in the same packet, but
Did you
I'm not
file a
sure.
demurrer on the same day in a separate mailing?
I did not.
Are you testifying to your office policy here? Or are you testifying to your recollection of what you did with the motions specifically filed into this case?
I remember that as to Miss Jens's case. Well, I have no idea what it has to do with this, but I have a specific recollection of filing the statutory speedy trial demand in Miss Jens's case. And I also recall actually preparing that document.
But it's true that you don't remember anything else about that day.
About that day, I think this is the most important thing that I prepared the documents on November 11th, 2021. But what I presume that you were referring to that date. But as it relates to the actual November 17th, that was the date that was filed into the clerk's office. There's a mailing delay that's associated with COVID there. I usually will also, I will file things whenever there is statutory speedy trial demand. I'll send it via certified mail with return receipt requested. But as you recall, during COVID, you would not actually get the green cards back. You would get a stamp that said COVID-19, and you would never actually have proof of it. So I was actually trying to ensure delivery of it to the parties by virtue of not sending it certified. That was the reason why I was doing that. Like, I was purposefully doing this.
But you did send 3 different mailings to the clerk's office for the
Not
day.
that I recall.
All right, no further questions, Your Honor.
Thank you, Mr. Sessions. You may step down.
Thanks so much. Should I just do a little redirect? I'm sorry.
Oh, you wanted to do, oh, sorry.
I'm sorry, I'm the worst.
Go ahead.
Mr. Sessions? Do you have any control at all over how the clerk receives your filings or puts them in electronically?
I have no control whatsoever over what the clerk does.
Have you ever been able to call down to the clerk's office and ask them to separate filings so that opposing counsel can more easily see them?
I have called and tried to get information about pending cases that, let's say, for example, a client was arrested at the jail. They get a expedited accusation. I just had this occur recently. And the clerk's office themselves, even with an assigned case number, will not be able to give me specific information about it. Finding the person who actually does the filing and who does the processing into our e-filing, our Odyssey system, and I say ours, I'm referring to the court system, is virtually impossible. Like, you cannot get an actual answer there. It's bureaucracy that I don't know how to navigate.
So let me ask you, when did you set up this policy of sending in unbundled documents? And why are you so confident that you did it in this case?
I set up the policy after Hannah Rogers. I fortunately, in Hannah Rogers' case, got through the case fortunately, for my client's benefit. I got through that case unscathed. But after that case, I realized how important this requirement was. I hadn't really thought about it before. It wasn't something that I was just by chance, I did it correct in that. It's sort of dumb luck. So be it. It was dumb luck in Hannah Rogers that I didn't actually do the thing that was prohibited, which was stapling or otherwise attaching it to a document. But after Hannah Rogers, I made it was a practice in my office that you would never attach these things to another document. And everyone who works in the office knows this. I say everyone. It's not like there's like some huge machinery here. It's me and my assistant who are there.
So very last question. Sorry, actually, I actually forgot what I was going to ask. It was a good answer. All right, thank you very much.
May he be released?
You may.
Thank you, Mr. Sessions.
I'm not going anywhere, Your Honor.
Thank you. Anything else, Mr. Fleischman?
No, Your Honor, unless you'd like to hear closing.
No, thank you. If y'all like to be seated, please.
If I may have an opportunity to respond, Your Honor.
Sure.
Right. So I just want to provide a distinction between the Rogers case that the defense keeps citing and the Genis case that we're dealing with in this courtroom right now. In the Rogers case, the Court of Appeals states that this speedy trial demand was not stapled or otherwise bound to any other document filed that day. And the state would contend that putting these all in the singular mailing, specifically on the very last page, would be considered otherwise bound to other pleadings. And accordingly, this should be denied. Right. And if you look at the docket from the clerk's office, there are 3 separate entries of 3 separate filings that the defense filed that day on November 17th, 2021. An entry of appearance, separately, a motion for discovery -consolidated, which contains this speedy trial demand on the 25th out of 25 pages. And thirdly, demurrers.
Anything else, Mr. Birch?
And Mr. Sessions put all of these in the same mail. And that is all, Your Honor.
Thank you. A demand for a speedy trial is a constitutional right. It is a right that must be affirmatively, expressly, and distinctly stated so that we start the clock on scheduling the cases. As a matter of practice, when the case is filed with the clerk's office and a speedy trial is filed, there is a distinct flag that appears on the case to let the clerk's office know, the litigants, the parties, and the court that this particular case is on the clock, so to speak. I don't like to address factors in particular cases where the litigants are playing a gotcha game. And with all due respect, Mr. Sessions and Mr. Fleischman, the Rogers case is puzzling, but it is also very clear. This was a situation where the court found that the separate motions were distinctly separated, were distinctly identified, so that a common layperson or common person or anyone reading it would clearly see that there are separate distinct motions, separate distinct demands, separate distinct documents. If we are going to apply Rogers to this case, to say as a matter of practice, the information that was filed on November 17, 2021 is a separate and distinct demand for speedy trial, I'm still failing to find it. First of all, in the Rogers case, the court specifically found that the information was hand-delivered to the trial judge, hand-delivered to the prosecution. There is a distinct method of delivery of service. Now, this may be me nitpicking about the details, but I am going to nitpick about the details because just as the defense is asking the court and the clerk's office to nitpick over a staggering stack of documents to identify the specific motions that have been filed, the court is also going to exercise it so. The state has brought up a very important factor, Mr. Sessions, or Mr. Fleischman, that in this particular case, there were 3 separate filings on that same day, identifying all 3 separate filings. On November 17th, 2021, the defense filed a separate document entitled Waiver of Formal Arraignment and Plea of Not Guilty and Entry of Appearance, filed on November 17, 2021, stamp file. It's a 2-page document and the certificate of service is on the 2nd page. The next entry was a significant stack of sheets of paper titled Motion for Discovery and Notice to Produce. That is the absolute title that was for a stack of 27 pages. And it's got a stamp file on the front page, November 17, 2021. And as I indicated, and as you've already highlighted to us, that each separate motion is separated. And you have the motion limiting to exclude all evidence. You've got your motion to suppress. You got a certificate service for that. You've got a demand for statutory discovery. And then you've got a certificate of service for that. You got a motion to dismiss on due process violation. Certificate of service is on the separate page. And then the last page is demand for speedy trial, 1 sheet of paper. It does not have the stamp file there because it was considered as part of a bound document, not physically bound, not bound by, I don't know whether it was bound by gem clips. I don't know whether it was bound by staples or rubber band or a string. I have no idea. All I know is that based on the testimony I've heard so far, a stack of documents was delivered and mailed to the clerk's office. Someone picked it up, stamped the top page. I don't know whether that person reamed through all of them to see the separate and distinct motions, because that whole stack of documents was filed as one with the title of the page 1 on the docket. And then right after that, we have a separate filing. And that's called the demurrers filed on November 17th, 2020, year 2020. And that also has a stamp file right there, November 17th, 2021. I'm sorry I'm going through this whole narrative, but this is me nitpicking. All right? And yes, a demand for a speedy trial puts everyone on notice. And Mr. Session, if that was that was the defense's intent, then that should have been filed as a separate document, as you did for your entry of appearance, as you did for your demurrers, not buried in a 27-page document. If the Georgia Court of Appeals intended such a filing to be adequate notice to the world that your client demanded a speedy trial on November 17th, 2020, the filing that was delivered to the clerk's office failed to do that. So
And Your Honor,
the notice that was provided for demand for speedy trial under the specific factors in this case, as distinct from Rogers, is insufficient.
and just for the purpose of clarification for the record, the sole factor here that we have failed to establish, we've established the jury notice, the two terms of court, that there was timely filed. The sole thing we have not done is proven that this was a distinct and separate document under 177170.
What we have established is that on November 17, 2020, the defense did not give notice of a demand for speedy trial
Okay, because it was not bound.
because there was no notice.
Okay, thank you.
Your Honor, will you enter a written order to that effect? It's directly appealable, so we just like a written
Get the
order.
transcript and submit a proposed order, and you can deliver it to Mr. Kenneth Randolph.
I don't want to submit a proposed order and deny my own motion and acquiesce to anything.
Okay, well, all I was going to say is denied, and then you can get the record.
Judge, if you could just enter an order.
Submit a proposed order.
Okay, I'll submit a proposed order.
No, thank you, Mr. Fleischman. All right. Anything else to address? The motion for this, all the other motions for this, to suppress, to exclude, and so forth are all going to be reset pending the production of the officer, correct?
Your Honor, I would like to go through the 17.825 factors for that. 17.825.
I'm sorry, I couldn't hear that 1720.
Oh, 17.8.
Oh, you can either use the microphone right there or the microphone right there.
I'm so sorry, Your Honor.
I am sorry, the human beings have to be attached to a mouthpiece. No, sorry. Okay.
And that's me. OCGA 17.825 sets forth a set of distinct requirements before the state can request a continuance for the absence of a witness. And I would ask that they be held strictly to the text of that statute. It requires that they prove that the witness was subpoenaed, that he resides within 100 miles, and what his testimony would be. For that reason, I would ask that the state be required to establish under 17.825 the factors required for this continuance.
Yes, Your Honor, 17.825 strictly applies to trial. We're not here for a trial today. This will be a motions hearing, and therefore the state is not required to prove those factors under 17.825.
Well, that's a quickie response. Mr. Fleischman, anything else?
Well, Your Honor, I'm not sure how you can say it only applies to trials. What's the basis for thinking that?
I agree with the state, but anything else, Mr. Fleischman?
That's it, Your Honor.
All right, the motion for continuance granted on the motion to exclude and suppress. And Mr. Fleischman will submit a proposed order on the court's ruling on the inadequate notice of a demand for speedy trial.
What
Would-
motion, Your Honor, just to make way, Your Honor, but a motion to dismiss for want of prosecution. The state has not established that the witness was subpoenaed, that he even had notice of this hearing. I haven't heard any evidence.
I've already granted the motion for continuance.
I understand this is a separate motion, motion to dismiss for want of prosecution, because the state.
I'm
failed to-
sorry, counsel, you have to come to the podium.
I'm just the worst. All right, let me move over here. I'm moving for that motion to dismiss for want of prosecution because the state has failed to establish this witness was under subpoena or even had notice of this hearing. I have not received any information to indicate this witness even knew he had to be here today.
All right, Mr. Birch?
Yes, Your Honor, and the state did file a motion for continuance in this case on March 13th, 2024, stating that GBI toxicologist Mary Jo Brasher is under subpoena, was previously placed under subpoena for today in Tattenall County Superior Court. And that That subpoena is attached as an exhibit in the state's motion for continuance.
I think Mr. Fleischman was asking whether she was subpoenaed for this hearing.
Yes, Your Honor. As an officer of the court, I represent that she was subpoenaed for this hearing.
All right.
Well, Your Honor, I object to that statement as an officer of the court and would like the certificate to prove service.
The motion to dismiss is denied. Mr. Birch, you can produce the subpoena at any time, and this continuance is going to take place. All right, now, what was I going to ask? Mr. Fleischman or Mr. Sessions and Mr. Birch, have you all had an opportunity to speak about this case? See if there's any other resolution?
I've tried to get someone to look at this case for 3 years.
Well, y'all are here. This is a good time to try because Ms. Waldrop and I are going to be busy with Mr. Hirsch's case next.
Happy to talk.
All right,
We'll
thank
do
you.
that. Thank you, Your Honor.
Haven't seen each other since what? No, we're doing this.
Nice to meet you. Hi.
I'm sorry, do you have to? Yes, it's going to be reset to the motions calendar, and that's going to be June 21st at 9 a.m.
Oh, it's a plea involved. You're the director. Thank you. You're the director. Yes.
Officer Richards, right? Are you Officer Richards? All right, just want to be sure. Thank you. Mr. Hirsch and Ms. Waldrop. As you can see, if we plan to call witnesses, they would have to be here, the mic's there. Mr. Hirsch, if you've seen Mr. Fleischman running around, you'll know where you need to be in order to be heard by a court reporter. Ms. Waldrop, please make sure your microphone is with you. Ms. Winfrey, I don't have any problem with you interrupting if you can't hear anything, all right?
Thank you,
Thank
Judge.
you.
Is this one not working as well? Okay.
This is State versus Tracy Fitzgerald. Is it Garrald?
Yes, ma'am,
Okay.
it's Fitzgerald.
Yeah, oh, it's
But I appreciate
Fitzgerald.
you attempting it. Nobody ever does that.
Tracy Fitzgerald.
Yes, ma'am.
All right. Case number 21 CR 0057550Y. This is on the defense motions with regards to this particular case in which Ms. Fitzgerald has been accused of driving under the influence of alcohol per se, driving under the influence of alcohol less safe, and possession of an open alcohol container stemming from a February 21st, 2018 incident. Ms. Fitzgerald, do you have a right to remain silent about the facts and circumstances of the case? Anything that you say can and will be used against you, so please only let your attorney speak for you unless he allows you to speak. All right, and you have a right to an attorney, and Mr. Hirsch will be representing you. Okay. Mr. Hirsch, I have a motion to suppress for lack of reasonable articulable suspicion and for lack of probable cause for arrest. I have a motion to suppress the results of the state administered breath test, a motion to suppress for, oh, is that a repeat? It's the duplicate. That was it.
You have the motion to dismiss and plea and bar?
Maybe that's the one I'm missing.
Your Honor, are you agreeing that?
We talked, we won't have a resolution today.
June 21st, please tell Mr. Fleischman that at 9 a.m.
Your Honor, in the interim, after we get to order, we'll almost certainly file, unless we get a resolution, and then
Okay,
we'll have it ready.
just tentatively then is scheduled for June 21st at 9 a.m. Sorry, but
I'll forget it as soon as I'm on.
oh, okay, go ahead.
June 21st at 9 a.m.
Yes. Mr. No, just all the motion to suppress, motion to exclude and so forth.
That will be the hearing on those motions that will be scheduled. Your Honor.
Yeah,
And obviously, if we have it, if we file in the meantime.
just let us know and the case will be stayed pending with outcome. Okay, take care, Mr. Yes, sir. Have a good one.
I appreciate it.
No problem. And I'm sorry, but if you just want to send me a one-page proposed order, that's fine. Do you have Mr. Randall's email? Okay.
Thank you, Mr.
Yes, we have the plea and bar. Do you want to start with that first?
Yes, please.
Okay. Mr. Hirsch, you may begin with your plea and bar. If
Okay,
you'd like
thank you,
the
Your Honor.
podium, so that Ms. Winfrey can hear you loudly and clearly.
Yes, I don't think that'll be an issue.
Ms. Winfrey, I don't have a problem with this audio. What do you think?
I can hear him.
That's okay. Thank you.
Your Honor, in this matter, the motion to dismiss and plea and bar is based on statute of limitations. This event happened on February 21st of 2018. The accusation in this matter from Fulton County State Court was more than 2 years later. The case was accused in they were filed October 25th, 2021. That is 3.5 years later. Now, in regards to the state, well, I don't think tolling is an issue, but just for the court's information, the tolling period because of COVID started in March of 2020, over 2 years after the statute, after the incident. So prior to COVID, or the state tolling order for COVID, the 2 years had run, and this accusation was filed, it looks like 3.5 years later. On October 25th, 2021.
All right. So your contention is that since it was addressed in the municipal court of City of Atlanta, City Court of Atlanta, looks like and the case was bound over from the City Court of Atlanta on February 14th, 2019. Would that be correct? Because you were the attorney of record in City Court of Atlanta.
Your Honor, that's what I have on my motion. I don't think I have a document with the express bind over date, so my guess is I looked up the City of Atlanta document.
I'm looking at the bind over material that was sent and filed with this court.
Oh, I don't have that.
Okay. And the accusation was entered on October 25th, 2021.
Correct.
And based on the bind over materials, it was the materials themselves were filed with court on November 29th, 2021. So you are calculating the accusation should have been submitted from the date of arrest, which was February
21st, 2018.
2018. So case was with City Court of Atlanta in February of 2018. It was bound over. Then the bind over notice of bind over was on February 14th, 2019, 1 year later.
I have February 28th on my motion, but I'm not looking at the docket. So, but in fact, I think we agree in February of 2019, it was bound over.
And then it was accused on October 25th, 2021. And then, so if I calculate it, even with the suspension and the tolling of the time due to the automatic standing order, could you explain to me how would this, because 1 year was taken up in the City Court of Atlanta.
Yes, Your Honor. I'm not sure that's relevant to the case law. It's not when statute of limitations begins from the date of the offense until the accusation is filed. It doesn't matter that it was in a different court first.
Okay. That's a new one on me, but I'll listen to what Ms. Waldrop has to say. Ms. Waldrop?
Yes, Judge. So a review of this case, it does show that the defendant was arrested on February 21st, 2018. And the case was subsequently accused in our office on October 25th, 2001. So yes, there was an order tolling the statute of limitations for at least a portion of that time, approximately 15 months or so. So we don't disagree that we would have needed to accuse the case by June 5th, I believe, of 2021. In order to move forward, I guess, on the accusation, it were the only document that we had. So the state would argue we are still not precluded from proceeding with prosecution in this case. And the reason being is that per the case, Judge, of Prindle versus State, that's found at 240 Georgia at 461, a uniform traffic citation serves as an accusation in any court having jurisdiction over the offense, with the exception, of course, of Superior Court. And prior to trial, the state can amend the accusation to change the allegations regarding any offense arising out of the same conduct which gave rise to an offense alleged or attempted to be alleged in the original accusation being the citation.
So when was this case accused then?
Your Honor, in our office, well, the case was accused when it was filed in the, when the citations were filed in the City of Atlanta Municipal Court. And I have those citations here for the court. They are certified. They are file stamped, and I can provide that to Your Honor if you'd like.
Yes, please. Let's show a copy to Mr.
Yes, I
Hirsch.
can provide.
Okay.
So that is when the case was accused. Now, when it was reaccused or amended formally in our office was on October 25th, 2021. But the case was accused on the date that it was filed into the City of Atlanta Municipal Court.
All right, Mr. Hirsch, anything else, Ms. Waldrop?
Just that is the accusation, and that is what we would be proceeding on.
So I guess that's where I'm a little puzzled, Mr. Hirsch. That was my understanding, that the traffic citations act as a accusation, especially when it goes through a whole year of litigation. You've filed motions for discovery, entry of appearances, you've shown up in court, plea offers have been considered. And then when you demanded a jury trial, it just got transferred to the appropriate court in order to exercise your client's right to a jury trial. So why would the subsequent accusation be why do you believe that the subsequent accusation of October 2021 is the original accusation that is barred?
All right, now I think I understand what the court was saying about binding it over a year later. So the answer is this, Your Honor. First, this is the first time I've received, this morning, I received notice from the state that this is what they were doing, that they had a file stamped copy of the citations and they were considering that the first accusation. There are no citations in Fulton County in the discovery I received from Fulton County. Regardless, statute of limitations can be raised at any time. It's an affirmative defense.
It is.
But the answer is that everything the state is saying is correct. They can do that if and only if this being the citations, if that is a valid accusation. In theory, a citation filed in the city of Atlanta or a municipal court can be a valid accusation, so long as it meets the same standards as any other accusation. And now that I'm receiving notice that this is what they're relying on, this is not a valid accusation because it doesn't meet the standards of Strickland versus State. It is subject to being quashed as a general demur. So I have a whole brief on it. I'd be happy to brief it. But like I said, I just received this today. But I can file a different motion now that they've given this to me. But under Strickland versus State, this clearly will be quashed. If it is quashed, then there's also plenty of case law, a couple of orders I have from other state court judges in this courthouse that if it is quashed, which it will be, that they cannot amend it.
Okay. Well,
And Your Honor, I'm sorry, may I just respond briefly? With respect to this idea that I'm obligated to share with defense counsel what my argument is going to be, I'm not obligated to do that. So yes, he did receive these citations from me this morning. However, he has been on this case, as you stated, since its inception in the City of Atlanta Municipal Court. And so he has been on notice of this case and of the citations. And in fact, he was the best person in the position to get the citations well before I would have gotten them, as he represented the defendant back in 2019 when this case was originally bounded over. So I just want to be clear that he's been on notice, although I'm not, obligated to tell him what my argument is with respect to.
Anything else, Ms. Waldrop?
No, Your Honor. Well, just briefly, Judge, with respect to his argument in Strickland. So
Have a seat,
Strickland,
Mr. Hirsch. Oh, if you're more comfortable standing.
so Strickland, in relying on Cargile, and I'll give the citation for Strickland, which is 349 Georgia Act 673. And additionally, the citation for Cargile is going to be 244 Georgia 871. And in relying on that case, it held that the phrase driving under the influence of alcohol is universally recognized and understood and is not deficient because it is indefinite or unintelligible. And so, Your Honor, when he states that the citations are insufficient, they are not. The citations state the charge of DUI. The citations state that it was under the influence of alcohol. It lists alcohol on the citation, as well as the fact that the defendant was less safe to drive. And that is with respect to the less safe charge. On the citation for the per se charge, it lists the statute. It lists that it is DUI. it states that it is 0.08 grams or more, and then up in the right-hand corner, you will see where it actually explicitly states the test result, which is 0.190 in this case. And so, Your Honor, that is sufficient to put the defense on notice of what it is that that the state intends to prove, and the allegation, and what it is that they will need to defend against. And so Strickland also states that the citation must either recite the language of the statute that sets out all of the elements of the offense charge, or allege the facts necessary to establish the violation. There is another case that Strickland cites, which is Power versus State, and that can be found at 231 Georgia Act 335. And in that case, the uniform traffic citation charged the defendant with DUI. The defendant contended that such a uniform traffic citation was vague and unambiguous, so that he did not know what he must defend against. And the court concluded that the phrase driving under the influence of alcohol, DUI, describes a specific method by which the crime of driving under the influence may be proved, and that the phrase, again, driving under the influence of alcohol, has been universally recognized and understood, and it has a universally recognized and understood meaning, so that reasonable persons could not differ as to its interpretation. And that meaning is that a person is under the influence of alcohol when it appears that it is less safe for such person to operate a motor vehicle. And so the phrase driving under the influence and the phrase to the extent that it is less safe for the person to drive, those are not two separate elements. They are equivalent concepts describing the same physical condition. So even if the citation did not state less safe, it would still be sufficient, because DUI is universally understood and recognized as driving under the influence when that person is less safe to operate a motor vehicle. And so even if a charging instrument does not specify to the extent that it was less safe to drive, it is still sufficient, because it puts the defense on notice of the way in which they have violated the statute. And so we would argue that the citations are more than sufficient to proceed on as the original accusations in this case.
All right. I think I'm here on a plea and bar on the grounds that the accusation that was filed in the state court of Fulton County should act as the original accusation and should be barred, since the original incident was in February of 2018. Question then becomes, was the citations as filed with the City Court of Atlanta act as the original accusation and then subject to litigation for almost a year, after which the defendant then filed an entry of not guilty and demanded a jury trial, from which then the case was transferred to the State Court of Fulton County. Upon receiving the bind-over materials, the State Court of Fulton County then filed its accusation to begin prosecution of this case. So, does the accusation as filed by the Solicitor General's Office of Fulton County, is that untimely? So, Mr. Hirsch, you're contending that it's untimely.
No, that's not the issue.
The incident occurred in February of 2018.
Right.
Right. The accusation that was filed in the State Court of Fulton County was in November of 2021.
Oh, yeah, we all agree that's untimely. I think the state agrees if it is the only valid accusation.
No, the question is, you're contending it's untimely. Okay, and they say.
Yes, yes, I thought you were talking about the citations.
And the state is contending that it would be untimely if I don't consider the traffic citations as the original accusation.
Yes, and I agree that you should consider the citations as the original accusation. It is the original accusation. The issue, though, is that only works if the original citation would survive a general demurrer. And I'm making a general demurrer now to it, which I can make at any time, including a trial in writing or orally. And it would clearly not survive under Strickland.
Tell me why it's clearly
Okay.
not survivable.
Sure. Couple of things. First of all, the Solicitor's Office interpretation of Strickland, I think, is not accurate. When the language that they quoted from Cargile, that is the language of that case. But when Strickland talks about that case, it says what they said, but they say that was said in Cargile, which was the state's argument in that. But the Cargile issue was not a general demur. The Cargile issue was a constitutional challenge that the old DUI statute was void for vagueness.
Why are these citations subject to a demurrer?
Okay.
What is so insufficient about them?
Okay, the answer is this. You read this like you would read an accusation. It has to track the language of the statute and have every material element in there. So DUI. First of all, it's not DUI. The first issue is it never even states the charge. Okay. And the case law is clear. Just simply citing the code section is insufficient. It actually has to track the language, right? You never see accusations in state court that say you're in violation of 40-6-391A1. All right. But so that's first, is the fact that the code section is there is insufficient. You treat it like you would treat a normal accusation. So here are the elements. Is it in Fulton County?
It was originally filed in City of Atlanta.
Yeah, City of Atlanta is in 2 different counties. I don't know that it says that this happened in Fulton County, so that would be 1. But if I'm missing that, sometimes it's written on there. So 1, it doesn't say it was in Fulton County. So it'd be, they have to accuse and prove venue. That's 1. 2, does it have my client's name? Yeah, it has my client's name. They're good there. Does it have where it happened? Yes, it says where it happens. I'm sorry, it does have Fulton, Your Honor. It says in the City of Atlanta, County of Fulton. So it appears it does have Fulton County. Does it say where it happened? Yes, it says where it happened. 1098 or 16, I think 1098 Washita Avenue. Okay, they're good there. Now, do they tell you what the offense is? Driving under the influence of alcohol? No, they don't. You would never see an accusation saying, hey, you're charged with HV, habitual violator. You're charged with FTC, following too close. You're charged with MM, malice murder. No, it actually has to say driving under the influence of alcohol. This says DUI.
This is DUI, alcohol, less safe.
Yeah, it doesn't say driving under the influence.
Okay, so it's the acronym that you have an objection to.
No, there's more than that. I'm going through each element.
Okay.
It doesn't say that they were under the influence of alcohol to the extent they were less safe. It just is citing words here. But there's another key element it doesn't have, and that is that she was in actual physical control of a motor vehicle. It doesn't have that anywhere. And the cases are clear. There's a remarks section, and there's nothing here under remarks indicating that. So that goes for the first one, the first accusation. The second one doesn't say grams of what. It says DUI test result 0.190, 0.190 what. Again, it just doesn't say she was in actual physical control of the motor vehicle. It doesn't say driving under the influence. So if this were to be an accusation, it would be insufficient on its face.
Right. Yes, go ahead, Ms. Walker.
So I do just want to point out that your original premise was correct. He was challenging that the accusation that we had filed in state court was out of time. If that was the original accusation, he concedes that the citation is now the original accusation, which would not make it out of time. But with respect to the sufficiency of the citations, they state exactly what is in the statute with regard to the elements. We have the county, which is Fulton. It's circled about midway through when it says in the City of Atlanta, County of Fulton. It's right above the location, which is Wichita Avenue.
I don't think Mr. Hirsch had a problem with that. It was
Right.
the narrative with regards to the description of the charge.
Understood.
The
and I've
use of
already-
acronyms, the fact that it lacks the language that she was in actual.
And that's what I
physical
just
control.
addressed in Strickland, which is that DUI is universally understood and recognized to mean driving under the influence to the extent that one is less safe. The elements are there. It is DUI, it is alcohol, it's not drugs, it specifically states alcohol, and it states that she was less safe, even though it wouldn't need to, it does. And so the citation is sufficient. I was simply going through and checking off what we have.
Yeah,
Um,
let's focus on the issues that are
sure.
in dispute.
I will. And with regard to Strickland, in that case, the subsections of the DUI citation were left blank. There were no remarks. And the court still found that because the phrase DUI, the acronym DUI, is universally understood and recognized to mean driving under the influence, and that is synonymous and equivalent to being less safe to operate a motor vehicle, that is sufficient to move forward on the citation. It gives notice and it alleges sufficient facts to put the defense on notice as to what they are being charged. And in this particular case, with respect to the DUI per se, it says 0.08 grams or more. And then under DUI test results, it specifically states 0.190. So the citations are more than sufficient.
And that's not, every material element that it's not tracking. So also like within 3 hours is supposed to be in there. So again, I just got these today. I'm happy to argue Strickland, but I'm objecting not just to what I orally object to, but to every material element that's not in the citations.
All right.
And I do not believe, like I've argued before, I do not believe Strickland stands for what they're saying it stands for. I will note, as Judge Taylor did yesterday in a hearing, similar hearing, that Strickland, Cargile, those are all cases where the citations were quashed.
In this particular case, the demurrer is denied. The citations as filed in the City Court of Atlanta, those were never challenged for over a year while this case was in litigation, while motions were filed, entry of appearances were filed, offers were considered, and ultimately the defendant exercised her constitutional right to demand a jury trial and had the case transferred over. What the state did was take the original citations, being the original accusations, and amended it in order to make sure that it conformed with the Strickland requirements of language. Now, at no point between the original filing until it was filed with state court were there any challenges to the language of the citations. And since it has been amended to conform with the notice requirements as set forth in a proper accusation, this case shall move forward with prosecution.
Your Honor, and I understand the court's ruling and respectfully object.
Understood.
Just so I know, what's the relevance of when I challenged the sufficiency of the citation? I mean, I can raise a general demurrer.
You can raise it anytime.
Yeah.
All I'm saying is that the original accusations as filed, they were subsequently amended.
Okay,
And the state has a right to amend the accusations.
right, okay. Can we, for the purpose of the record, can the state submit what they're referring to, the file citations, as an exhibit?
Yes, I can put an exhibit.
State's Exhibit 1?
That'd be great.
Okay,
Judge, you want me to label that?
yeah. Ms. Winfrey, there will be a State Exhibit 1, which Ms. Waldrop will email to you.
Thank you.
And just, my objections go to the other two charges as well, reckless
All right.
driving and open container.
You want me to write down State 1?
Please.
And this will go to Mr. Randall. This will have to be sent to Ms. Winfrey. It's on record. All right, are we ready to address the motions to suppress and for lack of reasonable articulable suspicion to stop and probable cause to arrest, and motion to suppress the state administered test?
Yes, Judge, Officer Richardson is present. I just want to, just clarify the issues on the record. I heard you say reasonable articulable suspicion, probable cause. With respect to the breath test, it is my understanding that the voluntariness of her consent is what's being challenged. I just want to, confirm that those are the three things we're moving.
Mr. Hirsch?
Your Honor, I'm moving forward on what's in my motions, and the breath test, among other reasons, any reason that it can be suppressed is basically an Elliott motion. So the state may have a different interpretation of what Elliott means. But back when Elliott was, before they fixed the implied consent, I think I've had my breath tests. Every solicitor I've ever dealt with had agreed to suppress the breath test, including this office, but it sounds like that has changed. So that's a legal argument. Happy to argue that first if you'd like.
Unfortunately, I'm not part of the usual course of business between defense counsel and the prosecutors. I can only make a ruling on the law and the facts. So is the state willing to suppress the breath test?
No, Judge.
Okay.
But if that is a legal argument only, then I will not address voluntariness or anything of that sort, and we can just address RAS and PC with regard to the officer's testimony and have a legal argument on the breath admissibility of the breath test.
I have no idea what Mr. Hirsch is proceeding
that-
on.
I'm not waiving anything. I'm just saying that
He's not.
the Elliott part of the breath
So if
test
you
is
wanna
legal
go
argument.
forward with that argument, since it sounds like it may be a legal argument, we can do that one first.
Okay, good. What is your legal argument with regards to the breath test, Mr. Hirsch?
Your Honor, under Elliott, as it's articulated in my motion, Elliott stands for the proposition that the implied consent warning is misleading. And therefore, if you refuse a breath test, it gave you an improper concept. It was coercive. And the legal holding is that because it's misleading, refusals, if you refuse to a state administered test of your breath, then the test doesn't come in. All right.
The implied consent rights as read on February 2018, you're saying is in violation of the Elliott rule, which was amended subsequently.
Correct.
Okay.
All right. Now, so then I don't think it's been litigated because, like I said, it hasn't been litigated. I think the solicitors that I've dealt with have all agreed not to then put a breath test in. And the reason is if it's misleading as to what happens to you if you refuse, then it becomes coercive as to what happens if you accept. In other words, you're making a decision between accepting to do a breath test or refusing to do a breath test. If they say, for instance, by way of exaggeration, if you refuse to do a breath test, then we will put you in jail for 10 days, starting right now. Do you want to do a breath test? And if you don't think, you've been told something, misinformation as to what a refusal is, now you've not been intelligently and knowingly informed about the totality of the test. So you're not making an accurate decision between refusing or taking the test. Therefore, taking the test, the information, the implied consent notice was misinformation.
Just to clarify, the implied consent as read in February 2018 was the state is requesting a test of breath, like bodily fluids, blah, blah, blah. If you refuse, your license will be suspended up to a year. That was the question that was posited to your client at the time of the arrest. Would that be correct, Mr. Hirsch?
What the implied consent was.
All right,
yes.
I just want to make sure there's no, you're not in saying that she was threatened with jail time.
No.
That was just a hypothetical you used.
Yes, by way of
But-
exaggeration.
Which would be also incorrect because she was already under arrest at the time that implied consent was read.
Well, I said specifically 10 days in jail. If you understand the argument without the analogy.
Okay, yes. Ms. Waldrop?
Yes, Judge. So, I'll start with Elliott, which stands for the premise that the refusal to a breath test is inadmissible. Correct. However, there is another step to the analysis of whether or not a breath test might be inadmissible when obtained under the old implied consent law or card, the orange card, which was red back then. And specifically, that orange card in Olivec, the court held, was not inherently coercive. Olivec was very clear that on its face, it is not inherently coercive. And so there is an analysis that must be done if we are going to determine whether or not consent to the breath test, consent to implied consent to the state administered test will be admissible. And that analysis is a totality of the circumstances of various factors, those factors including the age of the defendant, the education, the intelligence, the length of the detention, the idea that there was whether or not there was physical punishment that was used when obtaining consent, and the psychological effects on the defendant. So the analysis doesn't just stop at Elliott, okay? There is a further analysis for a consent to a breath test, which is a totality of the circumstances to determine the voluntariness of that consent. It is not just out because the refusal is out. That's clear. And so that's what I was getting at when I was asking about the voluntariness.
Anything else, Mr. Hirsch?
No, Your Honor.
All right. The motion to suppress the breath administered test under the current holding in Elliott's denied. Anything else? Then shall we move on to a motion to suppress? Ms. Waldrop, did you want to call Officer Richardson to
Yes,
the
Judge.
witness stand?
The state would call Officer Richardson to the stand.
And please make sure that mic is close to you. Officer Richardson, Deputy, do you want to administer the oath? Thank you.
Testimony from the day of these matters of the truth, the whole truth, never but the truth, right?
Yes, I do.
I state the name for the record.
Are you comfortable? Got a lot of paraphernalia on your belt, so.
I'm Senior Police Officer Joel Richardson.
Good.
Ms. Winfrey, can you hear the witness?
Yes, ma'am, I did.
All right, thank you. Please proceed, Ms. Waldrop.
Yes, Judge. Good morning, Officer Richardson. How are you this morning?
I'm fine, and yourself?
I'm good, thank you. Officer Richardson, can you tell the court how it is that you are employed?
I'm employed with the City of Atlanta Police Department as an officer,
Okay, and how long have you been employed with the City of Atlanta Police Department?
approximately 13 years.
Okay, and are you post-certified?
Yes, I am.
Okay, and what was your assignment with the police department on February 21st of 2018?
Police officer in FOD, Zone
Okay.
6.
Okay, and can you, I'm sorry, did you say FTD?
FOD.
FOD. Can you explain what your duties were as a police officer FOD?
To patrol the area to prevent crime, assist with citizens, traffic enforcement, and answer 911 calls.
Okay, and how long had you been assigned to that particular task or division?
Approximately 7 years.
Okay, and can you tell the court about your law enforcement training?
Went to the police academy, had about approximately 408 hours in the academy. After leaving the academy, I had several trainings in constitutional law, DUI.
Okay, any other trainings while you were at the academy?
I mean, there were several, you know, it's like we had like 408 hours, so it was very extensive.
And I think you told me you had training in report writing, is that correct?
Yes,
Okay, and what about field sobriety evaluations?
you had the basics.
Okay, and what is the basics?
And like your observation, speaking to someone,
Okay,
try to find if they're intoxicated,
okay,
listen to how they speak, what you smell. Any observation?
Okay. Any specific evaluations that you have training in?
We had training like the walk and training the one leg stand.
Okay. As part of your training, did you have the opportunity to do alcohol workshops or wet labs?
Yes, we did.
Okay, and explain what that was.
They would bring in several volunteers where some would consume alcoholic beverages and some would not. And
Okay,
you have to determine which one is under the influence.
okay. And is the purpose of that to simulate real life effects of alcohol on individuals in a controlled environment?
Yes.
Okay. Let me ask a little bit about your hands-on experience. As far as DUIs go, how many arrests would you say that you had had up until the point of February 21st, 2018?
I would say approximately give or take 40.
40, okay. And did every investigation of DUI result in an arrest?
No.
Okay. Now, you stated you were employed by APD on February 21st, 2018, correct?
Yes, I was.
Okay. And were you on duty on that particular day?
Yes, I was.
Okay. And about what time were you on duty?
My shift is from 11 p.m. to 7 a.m.
Okay. And were you in uniform to include your badge?
Yes.
And what about a marked police vehicle? Were you in that?
Yes, I was.
Okay. Did you have the opportunity to encounter a Black Chrysler Touring?
Yes, I did.
Okay. Can you tell me about that initial sighting of that vehicle and what you saw?
I was in the area, I'm patrolling that area, and I saw the vehicle parked at the side with the key ignition and the engine running. And it was occupied with a driver.
Okay. And you said the key was in the ignition
Yes,
and you said the engine was running. Is that correct?
yes.
Okay. And with respect to the driver, what did you see?
Well, as I exit the vehicle to patrol, to go up close to the vehicle to investigate, see the driver was okay. The driver was passed out.
Okay. And so you said you went up to the vehicle to see if the driver was okay.
Yes.
So was this a welfare check in a sense?
Yes,
Okay. And about what time on your patrol did this encounter occur?
approximately 11:47 p.m.
Okay. And can you describe that area of Wichita Avenue and what lies in that area as far as businesses?
That area has like one or two bars in the area,
Okay,
residents.
okay. And you stated that you approached the vehicle, correct?
Yes, I did.
Okay. At that time, did you encounter Miss Fitzgerald?
When I got close to the vehicle, yes, I did.
Okay. And when you got closer to the vehicle, tell me exactly where you were located in relation to the vehicle.
I was like right up by the door on the driver's side.
Okay. And where was Miss Fitzgerald located within the vehicle?
She was inside the vehicle in the driver's seat.
Okay. And tell the court about your encounter.
When I got to the vehicle, I knocked on the door several times trying to get the driver attention. It took a while before the driver responded.
Okay. When you say it took a while, do you recall exactly how long?
I can't tell you exactly how long, but on average, if just like knock once or twice, somebody would respond. I
Okay.
had to knock several times.
Okay. Would you describe Miss Fitzgerald as unresponsive?
Yes,
Okay. And did that pose a concern to you?
yes, it did.
Okay. Now, you stated that this occurred at Wichita Avenue. Is that in Fulton County?
Yes, it is.
Okay. And when you first made contact with Miss Fitzgerald, did I hear you say that you were right up at the driver's door?
Yes, I was.
Okay, so how far apart were you from Miss Fitzgerald?
A few inches.
Okay. Being a few inches apart, did you notice any odor that you could identify?
When I first started to speak with the driver,
Mhm.
when she spoke, I got a strong odor of alcoholic beverage emitting from her breath.
Okay. And so you would describe the odor as strong?
Yes, strong.
Okay. And did I hear you say it appeared to be coming from her breath?
Yes.
Okay. Were there any other occupants in the vehicle that could have been the source of the odor?
No, there was not.
Okay. What about anything else within the vehicle? Did you notice anything?
Yes, I observed some wine, which is like 4-pack. Then I observed one of the wine bottles half empty, and I believe one was also empty.
Okay. Did you ask Miss Fitzgerald whether she had anything to drink?
Yes, I did.
What did she state?
She said yes, she had I can't even pronounce the word. It's like a funny drink, which is alcoholic beverages.
Okay. If I provide you just with a copy of your report.
I have it here.
Okay, you have it. Do you want to just kind of not necessarily refresh your recollection, but try to determine how to pronounce it?
Yeah, 2 beers and a Jagmeister or Jägermeister, whatever. I don't.
Okay. So specifically, she said she had 2 beers.
Yes.
Is that correct? And what else?
And 2 shots of Jägermeister.
Okay. And did she say where she had those?
At a bar.
Okay. And as you're speaking to her, would you describe her speech?
Her words was slur.
Slurred?
Yes.
Okay. Now, you had never encountered Miss Fitzgerald before this particular night, correct?
No, I have not.
Okay, so how is it that you know her words to be slurred?
Well, most likely when you're speaking to somebody, even someone with an accent, your speech will still be somewhat smooth. You know, you can understand it more. You won't be like stuttering in between.
Okay. Okay. Did you ask Miss Fitzgerald to step out of the vehicle?
Yes, I did.
Okay. And what did she state in response?
She asked me for a couple of minutes before she stepped outside the vehicle.
Okay. Why did you ask her to step outside the vehicle?
Well, number one, she was unsafe to drive because I'm smelling the odor, and to perform ask a couple of questions and see how she walked.
Okay. And please describe for the court how it is that, well, first let me ask, how long did it take her to step out?
I can't recall exactly.
Okay. Can you describe for the court how she exited the vehicle?
She opened the door and exited the vehicle. She came out like a regular person.
Okay. When she finally exited, was there anything notable about how she stood?
Well, when she came to the wall, she would sway from side to side up to the point where I had to hold her so she wouldn't fall down.
Okay. Is it your opinion at that point that she could not walk without falling?
Yes, it was.
Did you make any observations about Miss Fitzgerald's face or eyes as you were speaking with her?
I observed that her eyes were bloody red.
Okay. Now, originally you stated that you approached Miss Fitzgerald to conduct a welfare check because you were concerned about this individual passed out in the vehicle. At some point, did your investigation turn into a DUI investigation?
Yes, it did.
Can you tell the court at which point that occurred?
When I was close to the car, speaking to her, having a conversation, and I'm getting the strong odor of alcoholic beverages and observing the alcohol contents inside the vehicle, that's when it changed from a welfare check.
Okay. And when she finally stepped out of the car, did you ask her to perform field sobriety evaluations?
Yes, I did.
Okay. And what was her response?
She agreed.
She agreed to perform field sobriety evaluations?
No, the breath test. She denied. She
Well,
was
I'm just speaking about the field sobriety evaluations at this point.
Oh,
When
she
she
denied.
got out of the car, you asked her to perform fields. What was her response?
she denied.
Okay. Did you also ask her to take a breath test?
Yes, I did.
Okay. And what was her response to that?
She said yes to the breath test.
Okay. Now, as a police officer, have you had the occasion to observe people under the influence of alcohol?
Yes.
Okay. What about as an individual, just layperson, regular person?
Yes.
Okay. And how often have you had the opportunity to observe individuals under the influence?
A lot.
Okay. Hundreds?
I would say so.
Okay. And are the manifestations that you observed in dealing with Miss Fitzgerald, were those consistent with someone who had been drinking alcohol?
Yes, it does.
And based on your experience and what you observed of Ms. Fitzgerald, did you have an opinion as to whether or not she was less safe to drive that evening?
Yes, I did.
Okay, and what was that opinion?
She was intoxicated and would be unsafe for her to drive.
Okay. Now, you stated that you asked her to take a breath test. Did you read her implied consent warnings? Is that how you asked her that?
I might ask her twice. The first time I just asked her verbally, and she said yes. Then she was arrested. Well, and then I read Georgia implied consent notice
Okay,
for drivers over 21, and then I asked her again.
okay. And where did you read that Georgia implied consent notice?
Right on the scene.
Okay, and you said you read the section for drivers over 21?
Yes,
Okay, and how was it that you determined Ms. Fitzgerald's age?
by her ID.
Okay. And officer, I am going to show you what I'm going to pre-mark as State's Exhibit 1, 2. Oh, my apologies. Now, officer, I'm going to show you State Exhibit 2.
Yep.
Just some questions about it. Do you recognize that?
It looks like the old Georgia implied consent notice.
Okay, so that's how you recognize it, as a copy of the old Georgia implied consent laws?
Yes, because at
Now-
the bottom, the new one tells you which test you want to administer.
Okay, so that is not your specific card, correct?
No, it's not.
Okay, and you don't have that card with you today, do you?
No, I tried to find it, but I couldn't.
Okay, but is that an accurate copy of the old implied consent warnings to your knowledge, and you may review it?
I would say yes.
Okay. Now, where was your original Georgia implied consent warning card kept?
In my duty bag.
Okay. And the one that you are reading now, is that the one that was in effect at the time of February 21st, 2018?
Yes, it was.
Okay. And did you read it verbatim to the defendant when you read it to Ms. Fitzgerald on that night?
Yes, I did.
Okay. Your Honor, at this time, the state would tender State's Exhibit 2 into evidence as the officers, a copy of the
Any
implied
objection?
consent warning that was read.
Any objection?
Yes, Your Honor, I object. This is a document that's been given to him. He doesn't have the card that he read from. He doesn't know that it's exactly the same language. Best evidence rules, the original should be here. So he's just been given a copy of something that he's been told is similar to what he had, but he actually doesn't have his card. I object.
So the objection is that because he doesn't have his card, he doesn't know that the document represents the information that's also in his card?
That's one objection. The other objection is best evidence rule. Where is
Okay.
the original? Where is I have a right to actually cross-examine the document itself, right? It's hearsay. And we don't have that document because he doesn't have it. This is a different document.
Understood. All right. Let's just respond to the best evidence rule.
Well, Your Honor, he's testified that he's misplaced his card. This happened back in 2018, so he does not have the original card. He can testify that, and he did testify that this is an accurate copy of what his card looked like, and it was in effect at the time. And so defense counsel is free to cross-examine him on that, but he's testified that this is an accurate copy.
Objection overruled. State Exhibit 2 is admitted.
Now, Officer Richardson, you stated that you read the notice for drivers over 21.
Yes.
Okay. What was the defendant's reply to your request?
Well, when I read it, she said, no to the field sobriety. But
I'm not
yeah,
talking about the field sobriety, talking about when you read her implied consent for well, first of all, what type of test did you request?
the breath test.
Okay, and what was her response when you read that to her, requesting a breath test?
She said yes to the breath test.
Okay. Who transported Ms. Fitzgerald for the breath test?
I did,
Okay, and where did you take her?
to the city of Atlanta jail.
Okay. And it in fact was a breath test that was performed?
Yes, it was.
Okay. And at any time, did the defendant request an independent test of her blood, breath, or urine or other bodily substance?
No, she did not.
Okay. One moment. Now that section for drivers over 21, did you read it in its entirety to the defendant?
So the-
Okay, and I believe you said you read it on scene, correct?
Yes, I did.
Okay, and can you go ahead and read that section as you read it to the defendant that night?
Georgia law requires you to submit to the state administered chemical test of your blood, breath, urine, or other bodily substance for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highway of this state will be suspended for a minimum period of 1 year. Your refusal to submit to the required testing may be offered into evidence against you at trial. If you submit to the testing and the results indicate an alcohol concentration of 0.02 grams or more, your Georgia driver license or privilege to drive on the highway of this state may be suspended for a minimum period of 1 year. After first submitting to the required state test, you are entitled to additional chemical tests of your blood, breath, urine, or other body substance at your own expense and from qualified personnel of your own choosing. Will you submit to the state administered chemical test of your breath? Well, it says designated which test you want.
So I want to be clear that you're reading the one that you read to the defendant. Is that the one that says for the drivers over the age of 21?
Yes.
I think you have the one.
Objection, Your Honor, that's not a question, I think.
Did you review the entire document?
No, I just read the first page.
Okay, so not just the first page. I want you to review the entire document and read the one specifically for drivers over the age of 21.
Yeah, objection sustained. I think,
Yes, Your Honor. The card has 3 different sections. I believe that he just read the wrong one, so I'm asking him to review the entire document and read the correct section.
Your Honor, objection, she's leading him, she's telling him, he's already testified, the question was asked and answered.
all right. I'll sustain the objection as to leading, and the state has a right to redirect the witness to review the document again. And
So
then you
I'll-
can ask your question again, Ms. Waldrop.
Thank you, Judge.
May I interrupt? Is there sorry, Judge. I've never received a video in discovery. I think it was sent to me. I couldn't play it. I think I've mentioned that to the state. Do they have a video they're gonna play?
I don't think a video was ever sent to you because I don't have a video. I have that there's no video available in this case.
Does that answer your question, Mr. Hirsch?
Yes, thank you.
Okay, all right.
Officer Richardson, can you please review what has been marked as State's Exhibit 2, which is the copy of the implied consent in effect at the time? Find the section for drivers over the age of 21 and read that section, please. Have you located that?
Yes, I have.
Okay, can you read that section to the court, please?
Yes, I will. This is an implied consent notice for suspects over 21. Georgia law requires you to submit to the state administered chemical test of your blood, breath, urine, or other bodily substance for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highway of this state will be suspended for a minimum period of 1 year. Your refusal to submit to required testing may be offered into evidence against you at trial. If you submit to the testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highway of this state may be suspended for a minimum period of 1 year. After first submitting to required state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substance at your own expense and from qualified personnel of your own choosing. Will you submit to the state administered chemical test of your blood or breath?
Okay. And you specifically asked for breath, correct?
Yes, I did.
Okay. And did you, you stated that the defendant's response was yes, is that correct?
Yes,
All right. And did you believe that the defendant fully understood what you had read to her?
yes, I did.
Okay. Did she indicate to you at all that she did not understand what you had read to her?
She did not.
Okay. And based on, you stated that you determined her age by her driver's license, is that correct?
Yes.
Okay. And how old did you determine that the defendant was?
She was over 21.
Okay. Do you remember precisely what age she was? Okay. Do you want to take a look at your report and determine that? Refresh your recollection as to what that age was?
On my copies don't have her date of birth.
Okay. If I give you a copy of your report, would you be able to make that determination?
Oh, no, sorry, that's in the,
See it? Okay.
yes. You need her current age or the age at that time?
I'm sorry?
You need her current age or the age at that,
The age at that time.
that's like 6 years ago. At least in the 40s.
Okay. Okay. Can you put the date of birth for Ms. Fitzgerald on the record, please?
04/27/1970.
Okay. You said April 27, 1970?
Yes,
Okay. All right. Now, you stated that you, let me ask this. How long was the encounter with Ms. Fitzgerald that you can recall?
the total incident,
Mhm. And if you need to review your report for timestamps, you may.
that's gonna be a few hours.
And I'm speaking of just your encounter with her out on the road. Approximately how long did that take? If you recall?
Maybe about 45 minutes to an hour.
Okay. And you stated that you transported her for the test, correct?
Yes, I did.
Okay. And were you present during the entire length of that time that the test was taken?
Yes, I was.
Okay. At any time, did Ms. Fitzgerald withdraw her consent verbally, her consent to submit to the breath test?
No, she did not.
Did she ever push the machine away?
No, she did not.
Did she ever attempt to not blow into the machine?
No, she did not.
Okay. During your encounter with Ms. Fitzgerald out on the scene, did you ever have to raise your voice or yell at Ms. Fitzgerald at any point?
I can recall.
Okay. And was your demeanor with Ms. Fitzgerald similar to your demeanor here today? Okay. Did you ever draw your weapon on Ms. Fitzgerald while out on the scene?
No, I did not.
Okay. Now, you stated that you were present for the entirety of the test. Do you recall the results of the test?
Objection, Your Honor. The foundation hasn't been laid. He didn't conduct the tests.
Your Honor, he stated that he was present. He also, I can also ask him about his citation, which is what he wrote. And the test result is listed on the citation. So I can ask him that if the court needs foundation, but he was present and he stated that.
Your Honor, that's like saying if someone doesn't know something in particular, it's hearsay, or there's a foundation problem, they can read the accusation, and because it's in the accusation, they can say it. I mean, whether he testifies about it today or whether it's hearsay information that he put in on a different document, there's still a lack of foundation in hearsay.
I'm going to sustain the objection. In part, you can inquire as to how the officer administered the breath test and what he observed and saw.
Okay, what did you observe with respect to the administration of that breath test?
I observed the person that was administering the breath test. I put the machine on and did the check, whatever they do. And they gave her clear instructions to blow into a tube.
Okay, and do you recall seeing the number on the machine that indicated the blood alcohol content?
When it printed out a paperwork.
Okay,
That's how I saw the number.
okay, so you have personal knowledge of what that number is?
Yes.
Okay, what was the result of the defendant's breath test?
Objection, lack of foundation, still hearsay. The breath test has to be done right. It's got to be operated on machines with all its working components by someone who is qualified to work it. The machine itself has to be, it has to be checked, calibrated.
Calibrated.
Thank you. He hasn't testified to any of that. So one, lack of foundation, two, hearsay.
Your Honor, hearsay is admissible and he testified in a motions hearing. Furthermore, he testified that he was present during the entire test, that he saw the number and that he has personal knowledge of it because he saw it on the printout. He saw her below.
Is this the officer who issued the citations?
Correct, Your
All
Honor.
right, the objection says overruled.
Can you go ahead and tell the court what the result was?
0.190.
Okay, and did you indicate that on the citations that you issued to Ms. Fitzgerald?
Yes, I did.
Okay. One moment. Well. Just in summary, Officer Richardson, can you please relay to the court those manifestations or indicators that indicated to you and gave you the probable cause to arrest Ms. Fitzgerald for, well, first of all, what did you arrest her for? What were the offenses?
DUI illicit, DUI per se, open container. And reckless driving.
Okay, can you just relay for the court, just very briefly, all of those manifestations that gave you probable cause, that you felt you had probable cause to arrest the defendant for those charges?
Okay. The reason why she got the 2 DUI charges, one she blew over 0.08 grams or more, and then you have the DUI, let's say. Those are 2 common charges. As long as she blow, you won't get the less safe with the DUI per se.
Okay.
And I observed the open container of alcohol in her car.
What were your observations with regard to her physical condition, is what I'm asking you about?
Oh, well, her eyes were bloody red, and when I took her out the car, she was staggering, basically, swaying from side to side.
Okay. All right. And you also indicated that you smelled alcohol, is that correct?
There's a strong odor of alcoholic beverages.
Okay. And I believe I recall you testifying that her words sounded slurred to your ear.
Yes, it was.
Okay, nothing further at this time, Judge.
Mr. Hirsch?
Thank you. Good morning. How are you?
I'm fine, yourself, sir?
Good, thank you. Your Honor, so, okay if I stand here?
Perfectly fine.
All right. Did you have either dash cam, did you have dash cam video at this time?
Oh, no, I don't.
I'm sorry?
No, I don't.
Okay, at the time of this incident, your vehicle did not have dash cam.
I had my body camera like that.
Okay. So no dash cam on your vehicle at the time of the incident, correct?
Exactly.
All right. And did you have body cam?
Yes, I did.
All right, tell me about the body cam.
How it works or how we use it, what you would like to know about?
Was it on you and was it working that day?
Yes, it was.
All right, and what is the purpose of you having body cam?
To videotape mine and everybody else's actions.
Okay, and did you turn it on that day?
Yes, I did.
Was it working?
Yes, it was.
So it captured, you were approaching the vehicle and everything up to the arrest, is that right?
Yes, it should, yes.
And although it wasn't probably facing Miss Fitzgerald when she was in the back of the vehicle, would it have picked up any audio in the police car?
Yes,
Would it have picked up, your reading of the implied consent?
yes.
So how come that, to your knowledge, why don't we have that body cam?
That's something you have to contact Open Records. I have no idea why.
All right, well, it sounds like how does that body cam get sent to the state of Georgia to the solicitor's office generally, if you know?
Objection. I don't believe he has personal knowledge of how that would be sent to us, so there's no foundation for his knowledge of that.
Overall, do you have personal knowledge, officer?
I know what we do is after each shift, you just dock it. And that's it. You assign the case number, you just dock it. Wherever it goes, then I don't know.
All right, so did you, after you dock it, it stays on a hard drive or some sort of storage device with City of Atlanta, is that right?
Yes, yes, depends on the nature of the case. What I know is certain cases stay 5 years and some stay longer.
What's the minimum amount of time it stays?
I believe it's 5 years.
So, this case is what, a little older than, this is 6 years old now? Yes. All right. Did you ever go back within the first 5 years to check for the video?
For this case?
Yeah.
Yes,
All right. And when you went to check for it, when was that and what happened?
I checked for like 2 to 3 days ago and I was able to retrieve it.
You have the video.
No, I was unable.
Oh, unable. All right. And do you know why you couldn't retrieve it?
When I put in the case number, it would not come up.
All right. And did you do anything to try and find it? You guys have like an IT person who can help you?
Well, I contacted my supervisor and informed her that I had court today. And she and all tried to retrieve it, but she was unable to.
All right. What's that supervisor's name?
Sergeant D. Brown.
Now, are you of the, it sounds like she did it quickly. Are you guys still trying to get it?
Well, up to this morning before I left to come to court, we tried to get it.
All right. Knowing that this will continue after today, can you make other efforts with other IT people or other people to try and get it?
That's above me.
That's above, all right. So who would be the person to contact for that? Sergeant Brown?
Open Records. They're the one that, if you want like evidence and stuff like that, they're the one you contact.
So 6 years later, that's the first time you tried to get this video?
Yes.
To your knowledge, is there a log that anyone else did get it or tried to get it?
Not that I know of.
Are you qualified, certified to run the Intoxilizer 9000?
No, I'm not.
You wouldn't know if it had all its working parts and was working as it's supposed to then, is that fair?
Objection, that is beyond the scope of Mr. Hirsch's motion.
Response?
Your Honor, it's subject to cross-examination. I don't think it's beyond the scope. I made an objection. The court ruled on as the foundation.
That was with regard to his knowledge of the test result. I specifically asked that issues be put on the record, and it was PAC, reasonable articulable suspicion, and that is what is in the motion. and then the voluntariness of the breath, of the consent to the test. There was nothing about the machine.
Right, he's got the officer on cross and the officer observed and indicated what he saw and what he observed. So I'm going to overrule the objection. And if the officer doesn't know the answer to the question, he can say so so, thank you.
You want me to repeat the question?
Yes, sir.
Since you're not certified, you've never been trained to run the machine, you wouldn't know if the machine was working as it's intended to work. Is that fair?
Yeah, that's a good question. I wouldn't know.
You wouldn't know, okay. And you wouldn't know if it had all its operating parts that were working in the right manner. Similar question.
Yeah, I wouldn't know.
You wouldn't know, okay.
Officer, could you please speak up because our court
Sure.
reporter is on Zoom. Thank you, appreciate it.
What happened to your implied consent card?
It's an old card. They gave us new ones, so there's no need for me to keep it.
All right, so you threw it away.
I wouldn't say that. It might be somewhere around, but
Okay.
it's,
You don't carry it with you.
I have no idea where it is exactly at, but.
Right, and you don't need it anymore. They replaced it.
Yes.
You told her that if she refused to take the test, that her license could be suspended for a year.
Maybe.
Maybe?
Yeah, maybe. When I read it, whatever Georgian Parkinson says, I read it exactly what it says.
Okay. I'm sorry, and you told her, you read it and you said if you refuse to take this test, that refusal could be entered into evidence against you.
Yes.
Now, do you know that that's not true because the law changed?
Yeah, I know the implied consent was changed.
Right. And so you told her at the time, take the breath test, or if not, if you refuse, the refusal will be admitted into evidence against you, correct?
But whatever the consent said, that's what I read.
And in terms of her understanding, you testified that she, because of alcohol and the breath test, well, a 0.190, she was extremely intoxicated to the point where you believe she had passed out, right?
Well, I went to do welfare check, so I didn't know exactly what was going on.
Okay. And so you would agree with me that someone in that state is not going to comprehend normal conversation or language as if someone is totally sober, right?
I would say that.
All right. And when I asked you specifically what you had told her in the implied consent, you yourself didn't remember it exactly. You said, whatever I read, correct?
Yes.
And you've read this 100 times or so?
Yeah, I read it a couple of times very well.
All right. So you actually, it would be then your opinion, in fairness to Ms. Fitzgerald, that just like you don't remember everything in it, at the time of the incident, she didn't fully comprehend what was said in the implied consent.
I don't know if she comprehended or not.
Okay. And part of what you said in the implied consent is incorrect. You read it right, but the implied consent card itself has incorrect information in it at the time. Right?
Well, at that time, I would say the information on the card was correct, but that's what they gave me.
Right. Agreed. But the law later said that that information is incorrect. The refusal will not be used against you in court.
Yeah, if you're talking about now, yes.
So that piece of information that you told her at the time when she had to make the decision was misinformation. Not because you did anything wrong, but it happened to be incorrect, right?
I mean, I just read what the law says at that time.
Understand. Okay.
So if it's incorrect at that time,
And you gave her a choice, either refuse, and that would be admitted into court against you, or take the state administered test of your breath. That's essentially part of the choice you have to take from the implied consent, correct?
yeah, basically.
And the consequences for choosing, again, you read it the part at the time, but the consequences for choosing that you told her aren't actually the consequences because the refusal will not be used against her, right?
Are you talking about now or back then?
Back then.
I'm not sure.
Okay. I appreciate it. No further questions.
Redirect?
Yes. Officer Richardson, he asked you, how does the video get to the solicitor's office?
Yes.
And I heard you respond that when you're finished with the video, you just,
Objection, Your Honor. This is a speech, not a question.
I'm asking him about the things he just stated on
Overruled.
the record. You stated that when you get done with that body cam video, you dock it. Is that correct?
Yes.
Okay.
Objection leading.
So overruled.
Do you have any knowledge whatsoever of how a video would get to the solicitor's office?
No.
Okay. Is it true that you only know what you do with the video after you quote unquote dock it?
Yes.
Okay. Now, with regard to this case, it was a while ago, but do you have some independent recollection of these events?
Yes, I do.
Okay. And when you were speaking with Ms. Fitzgerald, was it your impression specifically when you were asking her to submit to the test that she did not understand or comprehend what it is you were asking of her?
No, I just read it. And I said she would submit.
And did she appear to comprehend what you had read?
Yes.
Okay. Did she indicate to you that she did not?
No, she did not.
Okay. Is it your opinion that she was able to understand you asking her to perform field sobriety enough to say no?
Yes.
And she did in fact say no to that, correct?
Yes.
Did I hear you say that with regard to the video that you docked, that it does not stay past a retention date of 5 years? Is that what I heard you say?
There's certain ones you have to like speak to folks in open records, but from our knowledge, certain depends on how you categorize it. Most of it stays 5 years, but like other crimes, it will stay longer.
Okay. Nothing further, Judge.
No further questions.
Thank you, Officer Richardson. May the officer be released.
Officer Richardson may be released, yes.
Right. Thank you, sir. You have a good safe day.
Thank you, Judge.
Yeah, can you get out of it slowly, carefully? Thank you. Do you have state exhibits too?
Yeah.
Okay. No, sir. Yes, sir. Okay. Anything else from the state?
One moment, Judge. And Your Honor, the state would just call its final witness Sergeant McCarter.
Looks like it.
No, he's gonna be, sir, if you'd like to take that black chair and bring it as close as possible to the podium. You sure?
Yes.
Okay. It's not a very comfortable chair.
I see. Oh. You plan from it, next morning, you give the day's matter of the truth, the whole truth, nothing but the truth, so help you.
Yes,
Take your name for the record.
Michael Andre McCarter.
Sergeant McCarter, how is it that you are employed?
I'm employed with the Department of Corrections since 1999.
Okay, is that the city of Atlanta or?
Yes.
Georgia? Okay. And you said since 1999?
Yes,
Okay, so is that roughly about 25 years almost?
yes.
Okay. And can you tell the court what your assignment is with the Atlanta Department of Corrections?
Work day shift. Now at this time, now I work day shift. Intake supervisor.
Okay, what about back on February 21st, 2018?
I'm pretty sure I was working a morning watch, 10 to 6 shift.
Okay, and what would have been your duties?
Intake supervisor.
Okay, and what does that entail?
Do chemical tests, process people in and out of the facility.
Okay. And can you tell the court about your law enforcement training?
Yes, BCOT, basic jail certification. I am chemical test certified. I went to training down in Forsyth to operate the Toxilizer 9000.
Okay. And on February 21st, 2018, did you administer a test that required securing a sample of Tracy Fitzgerald's breath?
Yes, I did.
Okay. And what type of analyzer was used?
The Toxilizer 9000 was used.
Okay. And can you tell the court a little bit about your training in the operation of that machine?
The training of the machine is go through the theory of the machine, is how to set it up, how to operate it. And what I do, I have the police officer who just left. He brings the subject in, as for me to do a chemical test on. I do a chemical test. I enter my information, which is my name, my certification number. Then enter his name, police department he works with. Then I enter her name, her driver license, her date of birth, and all that information.
Okay. And have you received a permit issued by the Division of Forensic Sciences, which qualifies you to operate the
Yes, I do.
Intoxilizer 9000? I apologize.
Yes, and my certificate number is 932181.
Okay. And was your permit in effect when you conducted this test back on February 21st of 2018?
Yes,
Okay. And was your permit displayed in the immediate area where you conducted the test?
yes.
Okay. And where was it? Where do you keep it?
It's like in a binder right beside, if the machine's sitting right here, it's a binder right there. Because we have certain officers who are certified to do the test. When I set the system up, I open bind up and have my certification right there in
Okay.
plain sight.
Okay. And was your permit readily available to the defendant upon her request
Yes,
on that day?
yes.
And to what law enforcement agency is your intoxilizer assigned?
Department of Corrections, City of Atlanta.
Okay. I think you told us a little bit about how the test was administered when you talked about your training, but just for this specific case on February 21st, 2018, tell us how that test was administered.
Well, you set the machine up, the machine runs a certain test on its own to make sure that the machine is clear. And there's nothing like no ambient substances or something that it could pick up.
Okay. And part of administering to that test, that includes what you were talking about earlier about entering information into it?
Yes.
Okay. And is there any point at which implied consent is read?
Yes. Well, I have the officer, when they bring the subject in, I have them read it in front of me just for these purposes. I say court purposes, that I know for sure that implied consent was read.
Okay.
They have to do it in front of me.
Okay. And prior to and after the date of the defendant's test, had you conducted intoxilizer tests on that instrument?
Yes.
Okay. And on February 21st, 2018, did the instrument appear to be functioning properly when you tested the defendant?
Yes.
Okay. Did the instrument appear to have any components or pieces missing?
No.
Okay. Did it appear to be in good working order?
Yes.
Did it conduct any diagnostic checks on itself during the course of you conducting the test on the defendant?
Yes.
Okay. Did those diagnostic checks reveal any problems with the instrument?
No.
Okay. If it had, what would the instrument have done?
It would have alerted me that something was wrong with the machine, that I wouldn't be able to use the machine.
Okay. And how would it have alerted you?
It'll make a noise.
Okay. What is that noise?
Like a buzzing sound, or it will read out that something is wrong with the machine.
Okay. Was there anything at all unusual or irregular about the machine on February 21st, 2018, when you administered the test to the defendant?
No.
Okay. And Your Honor, at this time, I'm going to tender into evidence State's Exhibit, I believe will be 3 and 4. These are self-authenticating intoxilizer certificates. They are certified calibration certificates from the quarter before the test as well as after. And they show that the machine was calibrated at the time that it was in use on February 21st, 2018, and in good working order. So I would tender these.
Both
as evidence.
exhibits are for the Intoxilator 9000, is one the license?
I'm sorry,
Which one's for the machine?
both of these are for that
Okay.
machine. One is for the quarter before, one is for the quarter after.
After, okay,
It states that machine had been calibrated. These are calibration certificates.
okay. Mr. Hirsch?
And Sergeant McCarter, I just want you to review those really quickly.
Okay.
Okay, what is the serial number on those inspection certificates?
The serial number is 90-000-627 on both.
Okay, and when does it state that those inspections were completed? What's the date?
One was completed on Exhibit 458-2018, and the other one is on Exhibit 3-01-31-2018.
Okay, and are they both signed?
Yes.
Okay. Judge, I would tender those. Those are self-authenticating. Those are the calibration certificates. Tender those as evidence.
Mr. Hirsch?
No objection.
3 and 4, states 3 and 4 are admitted.
Okay. Here's the new one. And Sergeant McCarter, I am going to hand you what has been marked as State's Exhibit 5. You recognize that?
Yes, this is the copy of the intoxilizer, the results of the test.
Okay, and can you tell me what the serial number for the instrument is?
90-000-627.
Okay. And that matches up with the certificates that you just read out, correct?
Yes.
Okay. And I know you told the court what information you entered, but specifically with regard to that information, can you tell the court what that is?
I entered her name,
Which is?
Tracy Fitzgerald, her date of birth, 4/27/1970, her driver's license
Sorry.
number.
I have no objection to this document coming in
Okay,
for the purpose of this motion.
okay,
Right, state exhibit 5 is admitted without objection.
okay. And at what time did you conduct the defendant's test?
Time says 1:10, 28 seconds, that's 1 in the morning.
Okay, and what were the results of the first sample?
First sample was a 1.42, and the second sample was a 1.24.
Can you look at the sample where it says the defendant's subject sample is what it's,
Oh, I'm sorry.
can you see that?
Yes, 0.196,
Okay, and what was the result of the second subject sample?
0.190.
Okay, nothing further, Judge.
Mr. Hirsch? Your
No
witness.
questions.
Thank you, Sergeant Carter. You may we release? Yes. Thank you very much for being here. Oops. Okay. never mind. Did you get everything? You didn't leave anything on the table?
No.
No. Okay. Thank you, sir. Be safe. Your next, anything
Nothing
else
further
from the state?
Judge.
Nothing else. Okay, Mr. Hirsch?
No evidence.
All right. Closing arguments?
Yes, Judge. So with respect to the motion that challenged the reasonable articulable suspicion, probable cause, and voluntariness of the defendant's consent to the breath test in this case. So with respect to reasonable articulable suspicion, Judge, I would point out the case of Pierce v. State, which is found at 319 Georgia App 721. Stating that it is well established that an officer's approach to a stopped vehicle in inquiry as to what is going on does not constitute a stop or seizure and clearly falls within the realm of a first type of police-citizen encounter. Police officers may approach citizens, ask for identification, and freely question the citizen without any basis or belief that the citizen is involved in criminal activity, so long as the officers do not detain the citizen or create an impression that the citizen may not leave. So what you heard was testimony from Officer Richardson that this initiated as a welfare check. He saw the defendant in the car, in the driver's seat with the keys in the ignition, the engine running, and she appeared to be asleep or passed out or unresponsive. So he went to find out if she was okay. This was his regular patrol of Wichita Avenue. And he stated that this was unusual to see something like this. And so he went to check and see if she was okay. At that point, this was just a first hear encounter, Judge, to make sure that there was no ongoing emergency or medical services that were needed for the defendant. In Pierce, the first hear encounter occurred where the defendant was asleep at the wheel. The car was parked and running at a gas station. The officer approached, shined his flashlight, received no response, knocked on the window. The defendant rolled down the window, and then the officer smelled an odor of alcohol. It's very similar to what we have here. We have an engine running, we have keys in the ignition, we have someone unresponsive, unalert in the driver's seat of the vehicle. Officer Richardson approached, he said he knocked several times and did not get a response initially when he first tried to get the driver's attention. But then when he did, she woke up and spoke to him, and he could smell both the odor of alcohol. He could see that she had bloodshot and red eyes. And he noted that she had slurred speech, or what he described as speech that was not smooth. Because I asked him, how would you know it was slurred if you had never spoken to her prior to that night? And he clearly articulated why it is he believed her speech to be slurred. And so there's no need for reasonable articulable suspicion at that initial encounter, but he developed it as he spoke to Ms. Fitzgerald. And he indicated that he also observed within the vehicle that there were open containers of alcohol, that there was at least one open bottle of Gallo family wine. And so I think we overcome that standard. With respect to probable cause, as he continued talking to Ms. Fitzgerald, he noted those things that I just spoke of, the odor, the slurred speech, and then he asked her to get out of the car. And when she got out of the car, she began to stumble. She could not stand up. She was unsteady on her feet. She swayed from side to side, is what his testimony was. I asked him if he thought that she could walk without falling down, and he said no. So, Your Honor, all of those things get us to probable cause. He asked Ms. Fitzgerald to perform field sobriety evaluations. She declined. So there's no field sobriety evaluations here, but regardless, there is enough for the low standard of probable cause. He articulated those manifestations which he saw that gave him an indication that she was under the influence of alcohol. I asked him specifically whether or not he believed he had an opinion as to whether or not she was less safe to drive. He indicated that he did, and that opinion was that she was not. In the case of Durant v. State, that's at 319 Georgia App 866, states, even in the absence of field sobriety tests, the officer's observation that the defendant had bloodshot, watery eyes and exuded an odor of alcohol was sufficient to show probable cause to arrest for driving under the influence. Furthermore, in Schlanger v. State, that's at 290 Georgia App 407, it states the odor of alcohol emanating from a defendant's person, his slurred speech, his bloodshot and watery eyes, his unsteadiness on his feet, and his admission that he had been drinking were sufficient to show probable cause to arrest for DUI. The test for PC necessary to support an arrest requires merely a probability, less than a certainty, but more than a mere suspicion or possibility, and we have that here. Additionally, when he asked Ms. Fitzgerald whether she had had anything to drink, he testified that she replied she had had 2 beers, 2 shots of Jägermeister, and she had had those things at a bar. So, Your Honor, I think we have met and overcome the standard for probable cause. Now, with respect to the breath test, I asked Officer Richardson specifically whether or not he believed Ms. Fitzgerald to understand what he read to her in terms of implied consent, and whether or not it was his impression that she understood and comprehended that. He said that it was. He indicated that she did not tell him at all that she did not comprehend or understand. She was certainly able to comprehend his request for field sobriety evaluations and decline those. So there's no reason to believe that she could not have or would not have declined the breath test if she wanted to. I asked him whether or not he had yelled at her or what his demeanor or voice level was during his encounter with her. He indicated that it was much like what he presented on the stand, very calm and very cool and very collected, a very level voice, not elevated at all. I asked Mr. Officer Richardson whether or not he had a gun drawn. And he said at no point in time did that ever happen. He indicated that the detention was approximately 45 minutes, maybe to an hour or so. And that, Your Honor, is not unusual. The length of that would not be unusual in a DUI investigation. And so I also asked him what was her age around that time. And he indicated that based on the date of birth that was on his report, her age would have been in her late 40s. So the birth date was April 27th of 1970. That would have put her at about 48 or so years old, or 47, not quite 48 at that time. And so there's no indication that she was coerced or forced to give consent, and that her consent to this breath test was anything other than voluntary. I asked Officer Richardson, who was present throughout the duration of the test, whether or not Ms. Fitzgerald ever indicated to him a rescission or a withdrawal of her consent. He said that she did not. She never pulled her, pushed the machine away, or declined to do anything other than blow and give 2 sufficient samples, which resulted in 2 different results, as you heard from Sergeant McCarter. And so the state believes it has overcome its burden in showing reason, I don't want to say reasonable articulable suspicion for the stop, because it wasn't a stop, but articulable suspicion for the continued detention of Ms. Fitzgerald, probable cause for her arrest, and the voluntariness of her consent to the breath test. And I would ask that you deny the defense's motion.
Mr. Hirsch?
Thank you, Your Honor. I'm going to argue what I think the points that I think the court should rule in my favor on, not the stop or probable cause after the testimony. The first issue, refused the field sobriety evaluations. I believe that under the case law, that does not come into evidence. So I'll ask that not come into evidence. In terms of the implied consent, Your Honor, he testified basically of what he read. And then he said, this is the one I read, and he read the wrong paragraph. I think we know he read the wrong paragraph. Then the solicitor said, came up and said, no, read the one for over 21. And then he read the one for over 21. However, she didn't say, is that the one you actually read? She said, read the one you read, and he read the wrong paragraph in court. Then to try and correct that, she said, read the one for over 21, which he did. But she's never said, is that the one, the second one, the one you actually read? And without that, the testimony is that he read the wrong one. Because he read the wrong one, I think the case law is clear, the test is excluded. If they want to argue that he read the right one at the station, that would fail also, because they didn't say which one he read, A and B. If you read it incorrectly the first time when it's supposed to be read during arrest, and then even if you were to reread it at the station, then that doesn't cure the first problem. And there's not evidence that he read the correct one at the station. So I would ask that the test be excluded. In terms of Olivic and Elliott and that totality of the circumstances, you've ruled on it. And just to perfect the record, because there's more testimony. You know, the trooper or the officer himself testified candidly to what he remembered, very good officer. And he also didn't know the exact substance of what was in the implied consent, and he's read it 40 times. So to think that my client, who he says was so intoxicated she couldn't stand up straight, and he gave her misinformation, hey, choose A or B. A means your refusal will be used against you, right? That is, Your Honor, that is, as I've argued before, that should be excluded under Olivic and Elliott. So I would ask you to, if the states may consent to it, I don't know, suppress any refusal to a field sobriety evaluation or PBT, to not allow the state administered test of her breath in, because the officer read the wrong implied consent at the pertinent time, which was at the scene. That was his testimony. And or also to exclude the breath test result under Olivic and Elliott for reasons I've discussed.
And Your Honor, if I may, just very briefly.
All right.
I specifically asked Officer Richardson, which section of the implied consent did you read? And he stated the section for drivers over 21. Now, the implied consent card has on it 3 different sections. And so when I gave that to him, because I have to present him with the entire card, I can't just take out the section. I have to give him the entire card, or else there'd be an objection to the fact that I took out portions of it. I asked him to read the section that he read to the defendant. Mistakenly, he read the first page of the document that I presented to him. I then asked him to find the section for drivers over 21, which is the section that he testified that he read to the defendant on the night of February 21st, 2018. He did go back, read the entire document, and was able to then find that particular section, which was applicable here. So he did testify that he read the correct section, which was the section for drivers over 21. And he did then go back and read that section into the record. Now, he testified he doesn't have the implied consent card memorized. That's why he has a card that he keeps in his duffel bag. And that's why he reads it from the card verbatim to the defendant. So regardless of how many times he's read it, he doesn't have it memorized. He reads it verbatim from the card. But the appropriate section was read, and she consented to the test.
With regards to the motion to suppress for lack of reasonable articulable suspicion to stop and investigate, that is denied. I think even defense contends that there is sufficient evidence in there to establish reasonable articulable suspicion. With regards to the refusal of the field sobriety evaluations, is the state intending to bring the refusal in at time
You
of
can't
trial?
judge, you know that.
I just want to make sure that
Understood.
Mr. Hirsch understands that the state will not be bringing up her refusal of the field sobriety evaluations. All right, so that's not an issue for me to rule on.
It was never an issue, Judge.
And then now we come to the matter of the voluntariness of her agreement to take the breath administered test, or whether it was improper compelled testimony based on misinformation. The officer did read the wrong section from the exhibit as presented by the prosecutor at this particular hearing. I don't know whether the officer read that section as well at the time of the arrest on February 21st, 2018. He testified that he read the implied consent notice for individuals over the age of 21, but when he read the language from the exhibit, he initially read it for drivers under the age of 21. I find that to be an inadvertent mistake on his part, which was corrected, and the officer was rehabilitated on making sure that he testified that he read from the section for the appropriate age drivers. Now, if this had occurred during the course of a trial before a jury, that would be entirely up to the jury whether they would find the officer's error so bad that it would require an acquittal, or whether they would accept it as a inadvertent error and consider whether he read it from the appropriate card. That is the subject. I'm going to leave it up to the trial fact at the time of trial. But presently, for purposes of this motion, I do not find that there was any erroneous reading of the implied consent card that warrants a granting of the motion to suppress. Now, the third point. Whether the officer read information from the card that was the prevailing law in 2018 as opposed to it being subsequently changed after Elliott v. State was decided. At the time that Officer Richardson read the implied consent card to Ms. Fitzgerald, yes, that was the prevailing law. There was no reason for the officer to believe that he was giving her misinformation, and there was no reason to believe that she was being misinformed at the time of the arrest. Furthermore, based on the evidence that's been presented today, there's been no indication that Ms. Fitzgerald gave her consent because she also knew that that information was wrong, or that whether she felt compelled, or whether she was in a conundrum, and that she felt that she was giving this decision because she was being forced to do so. Ms. Fitzgerald, you have exercised your right to remain silent, which is the correct decision to do so. But based on the information I have no indication that you were compelled to agree to the breath administered test. The motion to suppress is denied. This case will be further noticed for trial. It will be scheduled for the next available ORCA jury trial calendar. Thank you.
Thank you. Your Honor, can I get the card of the court reporter? Would be okay? Or information?
She is Miss Winfrey.
It is Octavia Winfrey at Fulton County, the government.
Okay, so it's
Same one here.
all right. So
Thank you, ma'am.
it's Octavia, common spelling, .Winfrey, WINFREY, at fultoncountyga.gov.
Yes, thank you, Judge.
All right. May I be excused?
Thank you, Mr. Hutch.
Have a
Take
great
care.
weekend.
You too.
And Your Honor, that concludes the state's business. May we be excused?
Yes, thank you.
Yeah.
All right, Ms. Winfrey. Mr. Kenneth Randolph has all the exhibits, and you'll scan and email them to her.
Okay.
Yeah, I'm actually gonna go through, DeAndre.
Okay. The exhibits will come to you from Mr. DeAndre Moore.
Okay, great. I'll check with him when I get to the
All right.
office.
Thank you.
Is that was that our last case?
That's our last case. Thank you.
Okay, all right, thank you.
Bye-bye.